Testing. Test, test. Test, test. Test, test, test.
Monthly meeting, Sheriff Civilian Oversight Commission. Members of the department here to just carry out that discussion. So be discussing use of tasers, which have been will also examiner issues that use of security, autopsy reports, which we time how it's upsetting to the survivors of people shot by seeing so it's in schools and students, parents, teachers, everybody basically. So we have a lot to talk about. Discussion. Take the roll.
Good morning and public participation is important. WebEx opportunity comment. Items on the agenda. Will discuss following the committee taken. Wish to speak. Sign. If you're logged into WebEx, want to speak on an item, raise your hand. Have any technical questions or can't find the hand? If you're calling in, press star on your phone. If they call on you, 6 to all speakers will an announcement in Spanish. Le damos la bienvenida a esta reunión a miembros de la comunidad quienes prefieren
serves. He didn't think we had anyone. Understanding is that Arthur is to
So I just wanted to talk about an issue that had son and his girlfriend December 29th turned in, submitted to the Civilian Oversight Committee of the incident. So on the 29th, the incident occurred. The Palmdale Sheriff Department, obviously everybody, the DOJ settlement, sheriffs up there. So January 6th, I was, January 6th, I set up with, canceled the contract to have attorneys actually depose children. So precious to the Civilian Oversight Committee so that everybody understands what my son went through, his girlfriend. Just to give you a physical description, because I know that this type of work, y'all are probably the person that shot in Kentucky, and that it was a 6-foot man, turned out to be a 5'8" black teenager. My son is about that same size, smaller than him. So on January 6th, they came out, come out and do. January 12th, the Civilian Oversight Committee is staff to that incident, provided that report to the Oversight Committee. January 20th, I got an acknowledgement letter from the Palmdale Sheriff Department saying that they were investigating this incident. 2nd of January, Lieutenant Zamora spoke to then speak with children. On the 5th, he sent an email saying that if he did not receive a meeting notification, which we discussed on the 2nd, discussed on February 2nd, that we were going to. On the 5th of February, he said that I am going to close out the case on the 7th. Respond. He said that talking to me and my children and his girlfriend, the last piece to the investigation, and he didn't want the actual investigation to meander. He was going to close it out on the 7th. I then sent him an email and said we're going to have a meeting on the 14th. On the meeting, it was a recorded Zoom. I have that. I wasn't able, I could bring actual supporting, but I do have the meeting. It's recorded. Saying that he said I told him that it was going to be. So we recorded this meeting. During that meeting, Lieutenant Zamora stated that there was no report of the incident. Just high-level detail. There were it's in the report that y'all already have. I can resend that too. But to 5 police cars and 7 actual police officers to this incident. It's concerning about the report, seeming that son, to me, that determines fear of life. So a veteran of Air Force. So I know management, and you should have to have a requirement to report anytime you feel. That should be just 100% across the board. Then there was a backseat detention. Backseat detentions should be recorded and reported. How was my son going to have a gun pulled on him? Detained in the backseat? Any type of report that I have access to. In that, there was other stuff that labor point, but it wasn't due to safety. They were closed, that easily searched in the back seat with the window. December 29th, how cold it is at that time. It was called by my wife at around 10:30 while I was at a community event saying that this was occurring. So it's 10:30 at night in the Antelope Valley, desert area, very cold. So to me, that implies purposeful, because there's no reason to roll down the window in that case. So if they were going to say, we didn't put them on the curb because we, to make sure that they were out of the weather to actually protect them in that same case. While talking to Lieutenant Zamora, the focus was on that is very concerning. This is on the recorded Zoom of saying, problem is that I talked to them. Both very concerning to me, because to me, trying to isolate my children for no reason, have a full 4-page report. Your job is to investigate the incident. What he was trying to do was get them to go in and then say something opposite of the report, is what I feel that whole section was, that whole want and need to separate my child from me was actually there to, was the goal. He also said that he had not even talked to officers at that point. Now, I am a layman, and I wanted to preserve the information. So December 29th it happened, January 6th, I had someone sit with him. Raquel actually was there as well, because CTC, an amazing organization that gave me access to actual people that could help me. Otherwise, I would not have been able to do that. I did it almost 7 days after the event occurred, because it was fresh. They're completely traumatized, and I know what happens to memory as you go forward. We are on February 14th now. The officer, Lieutenant Zamora, had told me that the investigation was going to be closed, and then in this meeting told me that he had not talked to one officer. So how are they going to remember what happened on December 29th when they have probably had many incidents since then, and that there was no report actually taken? Obviously, he could be lying to me, because it is allowed for a cop to lie to a person. That's just allowed. So he could have had a report and just not telling me that there was a report. Still concerning. I asked for reports, and this is I want to make this to make sure that it's just understood that I asked for a report, body cam, any information that had already been collected from the investigation. He said, you're going to have to do a public records request. And then after he said you're going to have to do a public records request, he went on to talk at how long of a process and how long of a process that would be, as in almost discouraging me from saying that, there's so much red tape in this process that you don't even want to actually continue on. So what are my overall concerns? Well, my overall concerns is that I was a former co-chair of Cancel the Contract. I've since left the position. I'm a veteran. I work at Grumman. I have my own small business owner, employ over 100 people outside of that job. This happened to my son, and why is that important to note? I am one of a few handful of people in that community that actually was on Cancel the Contract. How often is this occurring? If one of my kids out of the small subset of a subset of a subset that knows that the Civilian Oversight Committee exists, that understands that the DOJ settlement is there, has read the DOJ settlement, understands all of my rights. How often this is happening to a person that does not know and cannot be here right now and did not and was also isolated, their child was isolated, they were discouraged from getting a public records request to get the information that they needed. The body cams, to me, I appreciate that they were there, but it's like a helmet to, for the community, it's like a helmet to a football player. It is a false sense of security. I have no access to that actual information. It takes forever for me to actually even get that information, to even ascertain, to understand how much in fear my son was to get guns pointed at him on that 29th. They are traumatized, and the whole thing that this does, the process that is designed right now, the whole thing is meant to continue to traumatize that person. They have to recount that information multiple times over and over without help. Young people that don't understand and get emotional and may say something because they are in fear. How are we going to help them? How are we going to help the Antelope Valley with actual accountability? We have a report, we have a decree, we have a settlement, we have no accountability. They get to do this, and right now, was the investigation closed out? I'll leave this after I say this. Was the investigation closed out? The investigation that I was told on the 14th was one step away, one meeting away from being closed out. Have I received any response from them since I showed that they could not bully me into actually allowing them to talk to my kids in an isolated manner? No. No response since then. It's April, almost the end. So I would love to have some sort of ability to hold someone accountable, to understand why was a gun pulled on my child? Why was it not reported? Because maybe there was a good reason. I think so, but maybe there was. Why wasn't it reported, and why does it take so long for me to get this information as a father who is in a community that is under a settlement? Thank you.
To agenda different reports.
Received. I think at a that the commission request of the here the report. What's a report? And essentially provide us with whatever information he can with the incident. He, first of all, wasn't a report. It has to be a violation of policy, sheriff's office policy, if no report is made to the police. If that's not policy, we need to demand that be policy. Sheriff's Department. I'd like to know why a body-worn camera wasn't on, or was it on? But in any event, I'd like the IG at least to take a look at this and maybe
I think that they already have.
Our office did speak to Mr. Calloway. It has been referred to OIG, and our staff last week was following up. So if there's documentation, to the commission. I believe staff spoke with Marisol.
And I can't speak to whether the settlement agreement requires a entry to go to RIPA, so that there should at least be, I think it's usually under Ad and SACR, And so that is a reportable event pursuant to RIPA that the department at least has to enter in their system. And then, so we'll look into it. It's not a problem at all. Obviously, Marisol already is. But now that I know about it, I'll go ahead and follow up. It's probably in my
Is that-
report here.
Is that
Yeah, so it's a legislative act where essentially it's all the data that goes to the states, and it's a racial instance, racial something. Decker knows.
Where stop enforcement must their perception of the race of the individual, nature of the stop, and it's maintained in a data.
Decker, you respond now. Just like to know, let's see if it's pulled. To require
That I know there isn't, because we did I know there isn't because we did a report on Santa Clarita, unless they've amended policies. When we did a report on an incident in Santa Clarita where there were guns pulled on children, there were in fact reports written, but there was nothing in the policies at that time that indicated that that was a quote reportable event. There were reasons why in that event they did write reports, but we looked at their policy. Now,
Commissioner Bonner, the policy is being, it's currently with Justice where it's in the final stages of DOJ process, and we're meeting next week on that.
Thank you for that. You could report.
child that isolated, or has this happened more than once in that area?
Okay, so some reports and then.
Chair Kennedy. Chair Kennedy, right here. I know it's rather difficult to know what's going on here. Could I just ask a question? We keep referring to the child and could we ask the gentleman who made how old is your son? I'm sorry, 22? And how old was the other person involved? I'm sorry, I can't hear you.
It's 22,
Uh-huh.
and then she is younger than him by a year or two, so 21, 20.
Okay, thank you very much.
Yeah.
Thank you.
But I just want to note that that's still a child. You know, that is my child that we're talking about,
understand.
just so to make sure. And,
understand.
and I don't understand why would we allow Harvey Weinstein to make the rules? You know, like, they are the ones that are being the abusers. Like, we need to actually have more external people making these rules and making them enforce the rules and the accountability on them. I don't understand how this keeps working because we keep spinning our wheels.
Well, that's what we're here for. I mean, it's your point's well taken. But we're here to have a robust discussion of the issues, including the scenario, which is quite troubling that you described. So I appreciate you coming to tell us that. We're going to move into reports and then we're going to go into tasers. First is the chair's report. I just want to tell everyone that this commission held a special town hall on the impact of deputy gangs on communities. Our first one was last Saturday in East LA. I really appreciate the commissioners who participated to make that discussion happen. We had, I think the estimates were approximately 100 people in attendance, and it went long. There was so much, so many people had so much to say about their interactions with deputies who they believe are banditos, the hurt and pain that they experienced as a result of a loved one being killed, and a fear of law enforcement gangs that exceeds even their concerns about street gangs. And, you know, that process was very difficult, but it really brought home the importance of continuing to shine a light on this issue and try to have significant, meaningful reform. Next is the Executive Director's report. Danielle, do you have anything to report?
Yes, I just wanted to announce to everyone that the commission will be having an upcoming virtual conference on the jails on May 4th. And then on May 13th, we'll be having a town hall in Palmdale. And you can go to our website, coc.lacounty.gov, to get further information.
YG? Dara, anything you want to report?
Well, there's two reports. Those specifically, I just wanted to quickly mention the addressing racial disparities in traffic stops, because I think it's a very important report. And LAPD implemented a policy, I believe it's over a year ago, based on their studies of traffic stops and the indications throughout the state that there's significant racial disparities in people stopping based on their percentage of the population. And the report makes a number of recommendations about policy and adopting policies to ensure that essentially that public trust in policing is not further eroded and perhaps improved. So the recommendations are very important. We met with the department, and the department indicated that they would consider the recommendations made by the OIG, and they're very similar, if not identical, to the current LAPD policy. And we believe strongly that the people of Los Angeles County deserve to have the same policies in effect at both agencies in order to approach, 21st century constitutional policing. So, and then we previously reported on consent searches. LAPD also has a policy on consent searches that's mentioned in our report as well. Yesterday, there was a hearing, since jails were mentioned, on the Rutherford case. It was a contempt hearing with regard to the conditions and wait times at IRC. And the judge in that case did not hold the county in contempt at this point, but they will be calling live witnesses in 60 days to discuss the conditions at the inmate reception center. And so we don't know what Judge Pregerson will do, but at least there will be a record of individuals with direct knowledge of what's happening at the inmate reception center, because the temporary order that the judge issued is being violated on a regular basis. So.
Thank you. Are there any, we have various ad hoc committees doing a bunch of good work. Is there any reporting on ad hoc before we go into tasers? Rob?
I think just a brief report. I don't see Lael Rubin here, but we just suffice it to say that the ad hoc committee with respect to deputy gangs did have an opportunity to meet with the sheriff. I don't think it's appropriate to discuss details of those discussions, but suffice it to say that we're still waiting for sheriff to indicate whether and hoping that he will adopt the recommendations of the Civilian Oversight Commission that were recommended by this commission on March 3rd, so it's over a month and a half ago. But especially, there are 27 recommendations, and I realize that there are different considerations with respect to each, but I just want to say on my own behalf as a commissioner, that I'm really urging the sheriff to, if he can't get to all 27, recommendations A2 and A3 are a policy to prohibit deputies from, in the future, joining or participating in deputy cliques and deputy gangs. And I would certainly urge the sheriff, I know he couldn't be at the meeting here, but I know his representatives are, to adopt those two recommendations post haste. I think that would send out a very, very strong message. I think that message is needed. We're ever going to rid the sheriff's department of deputy cliques and deputy gangs. Thank you, Mr. Chair.
Thank you, Rob. Anyone else?
Yes, I just wanted to just remind people that Ad Hoc Committee on Confinements of Jails will be having that virtual. It was mentioned, but it's very important that we're trying to partner with some of the other agencies in the area to get more information so that hopefully we can correct some of these conditions that have been going on a little bit too long. I have made contact with the Civil Brand Commission. I attended their meetings, was very concerned about some of the conditions that are there and have continued to be there. And I'm really hoping that things must change. I think those conditions are inhumane. Thank you, Irma. Final report is from the Sheriff's Department, and Under Sheriff April Tardy is here to represent the department. April, thank you for attending this meeting and hearing out all the various issues that we're going to vet today. I really appreciate it.
Very welcome, and thank you to the commission for allowing me to be here and to share some of the things that we've been doing since our last meeting last month. The sheriff, of course, would love to have been here, but he is at a conference, so he sends his regards. Commissioner Bonner, you spoke about the recommendations, and we are taking them very seriously. And we want to do a well-thought-out, sustainable plan. So it's going to take us a little bit, but we are working at all of the recommendations. And in addition, I know you spoke about the policies. Ms. Decker has been spending a lot of time and hours working on policies and messaging. So it's not going unheard from us. For the room, we have a lot of new hires. We've hired a few additional positions, team members for Ms. Eileen Decker's office and for the Office of Constitutional Policing. We have Eric Strong, who is seated here at the front row, if you wouldn't mind raising your hand. He is a master at community engagement, so he is responsible for putting together our town hall meetings, our faith-based organizations, and getting law enforcement and the community together again. We have Ed Madrano. He is a former chief of police and formerly from the DOJ's office, and he will be ensuring that our training is clear on deputy cliques and moving us forward. We have Barney Malikian. He's a former police chief and undersheriff, and he is accessing or assessing our current executive training and ensuring that we all receive, as executives, captains and above, the training that we need to move our department forward and with our engagement efforts as well. We have Mr. Steve James. He's formerly Long Beach Police Department. We have brought him on to assist us with dealing with our unions and all of our labor organizations, both sworn and professional labor organizations. We do have several people who are in backgrounds right now. Our background process sometimes takes a while, especially with funding and getting all of the positions through our CEO's office, but everything is flowing and hopefully we'll have some assistance for Eileen in the next month or so. The Office of Constitutional Policing, we have, like I said, Ms. Decker is working on the policies for gangs and cliques and tattoos. And also Ms. Williams brought up the STOP policy, and we are adopting the LAPD model of that policy. So we are a draft version of that right now. And Ms. Decker has been working with the Assistant Sheriff, Bruce Chase, on that. So I wanted to give you an update about the law enforcement working group that has been discussed a couple of different times. The task force meets monthly. I oversee the task force. It's made up of about 20 or more people. Right now we have every single area of our responsibility in this meeting. We have patrol, custody division. We have training, courts, Special Operations Division. We also have 2 members from Office of Inspector General, and we have labor on board. So the group has been developed into smaller groups or subgroups to address 5 different areas of concern. One is the messaging. What is our message so that it's across the board the same message that we're putting out to our personnel? Media. How are we going to handle the messaging? How are we going to convey our message to the public and to our employees? We have training, so we're thinking about training videos, academy classes, patrol schools, and supervisory schools, and recurrent briefing. Issues like this, we have to include recurrent briefing. We don't want to turn around 5 years from now and have the same problem. So we want this to be every single week, having briefings regarding this issue. We're also considering a cultural consultant, taking a look at a train-the-trainer type of curriculum where our focus will be on preventing cliques from establishing tattoos, discouraging tattoos. So, thank you. And just to try and eradicate the behavior. So we are looking at a cultural consultant to assist us with that. And lastly, it's the last group is just kind of focusing on what we have done in the last couple of months. So those are the 5 subgroups of this working group. And our next meeting will be next week. Wanted to talk to you a little bit about community engagement and a program that we had a pilot on about 2 years ago. And the pilot was with a company called, or an organization called Game Changers. And Game Changers is where you pair community groups with law enforcement. You sit at the table, you talk about deputy-involved shootings, you talk about stops, you talk about fear of law enforcement, and all of these things together at the table. And then once the meeting is done, the group collectively goes to either a collegiate game or a professional game, and we sit together. So it's truly bringing the community and law enforcement together. And again, that CEO is Sean Shepard. I had another meeting with him last week. We are looking to do a contract with him. We are looking for funding. And what I want Sean to focus his attention on is bringing the deputy cliques, gangs, subgroups, tattoos, all those issues to the table for our community so we can have the dialogue. And lastly, I wanted to talk about our crime stats in our area of responsibility year to date. As of yesterday, we had an overall decrease in violent crimes by 7.5% and a 1% increase in our property crimes, specifically burglaries and larceny thefts. I attribute the decrease to the hard work that everyone's doing, including the community. There are a lot of business watch groups and neighborhood watch groups that are assisting law enforcement in keeping the crime down. And that's all I have to report unless there are any questions for me.
Thank you. Any questions?
Just a little bit, It's just not clear to me exactly what the task force, the purpose of it is. You probably stated it just didn't register, and then it's divided up into 5 subgroups or 5 areas. So I realize what the composition is. I realize it's a process tool, but what, is it all issues facing the sheriff's department? Does it include custody? Does it, I mean, just kind of describe what it's going to be doing weekly and what issues it's looking at.
Yes, sir. And it's specifically to deal with our subgroups, law enforcement gangs, clique issues, tattoos, and messaging. How are we putting out our message to discourage our employees that are currently working with us, our employees, future employees, what we will accept and what we will not accept. So the group is put together to have the conversation and to attend briefings to talk about the culture and changing the culture of the department.
Thank you, and so it's good to hear, but I kind of missed that point, at least I did. Thank you, April.
And Commissioner Bonner, I would just add, its overall objective is to achieve the recommendation presented by the COC in its report to have an internal system working within the department to change the culture.
I have a question, April. We learned, obviously, that 2 deputies, or I guess former deputies, were indicted in federal court for holding a young person, I guess falsely imprisoning him, injuring him, lying about it, false reports. And of course, those 2 deputies were the same deputies involved in the fatal shooting of Andres Guardado. And the DA declined to file charges for that shooting, but they mentioned that the 2 deputies, Miguel Vega and Christopher Hernandez, that there had been reporting in the media that they were affiliated with or seeking to be affiliated with a deputy gang called the Executioners. And but the DA's report doesn't really say anything other than there were allegations in the media about that. And I'm wondering if the department has investigated them for that issue, because it seems like an incredibly important issue for everybody.
Mr. Kennedy, I'm not aware, I have not read the DA's report. I do know that they did not file charges under the Guardado shooting. I have not reviewed the case in some time. I would have to take another look at the entire case to find out what charges were actually, or policy violations were actually charged. And also, if memory serves me correctly, I remember we expedited that case. And we ran a concurrent investigation on that one. So I'll have to look further into charges, additional charges.
So is the answer we don't know then if the department investigated whether those 2 indicted deputies are in fact linked members of a deputy gang, or we don't know?
I don't know at this time. I would have to research the case again.
It's a really high profile case out there. It's caused a lot of concern in the community. Okay. I think we have to take public comment before we move to tasers. How many public comments do we have?
We don't have any in-person public comments.
Great. Because of,
I would just like to add, Under Sheriff Tardy, we appreciate your presence here today. I do want to note that you have shied away in your statements from use of the word deputy gangs or use of the term. And I want to just recognize that we have taken great pains as a commission. There's been months and months and months of work to document the existence of the problem of deputy gangs through a series of 8 meetings and a report just issued last month. And I just want to ask if you can be plain in use of that term without flinching, and to make sure that there's no receding or denial or efforts to slip back in time in the assertion of the existence of the problem. And plain use of that term, rather than fudging or rather than hedging, would be a great step forward in the confidence of the commission and I think of the public that's taken so much time and testimony to document the existence of the problem.
Look, I need to intervene here because to defend the undersheriff, because it's absolutely essential. No, it's absolutely essential that we understand that every deputy gang derives from a deputy clique, an exclusionary subgroup. And our report itself recognizes that. And so it's not just about deputy gangs, it's actually also prohibiting and banning joining and participating in deputy cliques. So you can use it for shorthand. Obviously, deputy gangs are pernicious, we want to get rid of them, but to do that, we also have to get rid of deputy cliques. This is and by the way, I know, Hans, you weren't on the ad hoc committee, but we went through this issue and we tried to make it plain in the report that we're talking about both things. So to the extent that both terms are used, I think it's acceptable and it's permissible. And if the only thing the Sheriff's Department did was to have a policy to eliminate deputy gangs, we'd still have deputy cliques that are going to emerge into deputy gangs. So we've got to do both. But with that, with that defense of Under Sheriff Tardy, I'll let her respond.
Thank you. And like you said, Commissioner Bonner, I have used the term deputy gang, I've used deputy clique, I've used group, I've used subgroup throughout. And I think that moving forward, the department has a strong passion for removing all of the elements, however it's termed, from the Los Angeles County Sheriff's Department, because it is harmful not only to our employees, our communities, and everyone that is impacted by it. So I hope that's clear.
I just wanted to comment how heartened I am that we're now actually hearing a new term, changing the culture, and that you seem to be really focusing on that. And we're going to be very interested to hear how that task force develops, hiring consultants, exploring. I mean, every organization has challenges with entrenched cultures. And so I'm really glad that you're also, you've got a new term, changing the culture.
Thank you.
Okay, going to move into our first substantive agenda item. I think it's the discussion of tasers at LASD. This was requested by our Tech Ad Hoc Committee, and I'm going to turn it over to Hans to introduce the topic and lead the discussion.
Thank you, Chair Kennedy. And I'd like to recognize my other ad hoc committee members on the Technology Committee, JP Harris and Luis Garcia. You all have likely seen media reports about law enforcement agencies throughout the nation and their use of tasers. The Commission's Technology Ad Hoc Committee is conducting research and analysis into LASD's policies, procedures, and use of tasers in our communities. To build upon the work of the Ad Hoc Committee, we invited two guest speakers here today to discuss LASD's use of tasers. LASD Custody Training and Standards Bureau Sergeant Michael Mabee will discuss LASD's taser policies and procedures, part one. Number two, the types of tasers that LASD currently uses. Number three, data related to the use of tasers by station and operation. Number four, data on complaints related to the use of tasers. Number five, any obstacles with the use of tasers that LASD has identified. And finally, number six, an overview of LASD's taser training program, including the percentage of deputies who have completed the program. Also, American Civil Liberties Union of Southern California's Senior Staff Attorney, Adrienna Wong, will discuss the community perspective on LASD's use of tasers and community input that they have received and reflect in their own work. After both guest presentations, the floor will be open for commissioners' questions and those of guests. And we're also looking to be hearing from the public on this item. And before we shift to hearing from Adrienna Wong from the ACLU, I just want to note and thank the commission staff for the solicitation of public comments conducted through the second half of March. I want to recognize that we did receive extensive public input on the request for public comment on taser use by LASD, and some of those will be reflected in forthcoming reporting by the Ad Hoc Committee. And with that, I want to recognize and thank Adrienna Wong for being here today from the ACLU of Southern California. Ms. Wong, it would be a pleasure to hear from you.
Thank you for the invitation, and I know you have a packed agenda, so I'll try to be brief. In speaking about tasers, I thought it would be good to start with the statistics that we do have, specifically about deaths that result from the use of tasers. So we know that there are over 1,000 deaths nationwide that have resulted from the use of tasers, and quite disturbingly, we know that 9 out of 10 people who died after being shocked were unarmed. This is from a in-depth Reuters report from 2017, and so since that was a little bit ago, the number of deaths most certainly has increased. There have certainly been deaths resulting from taser use in LA County, for example, since 2017. The graphic you see on the right there that has 65 deaths noted in LA County resulting from the use of tasers is also from 2017. We have more recent data from the use of force data that law enforcement agencies are required to report to the State Department of Justice. And from that data, we know that there have been almost 150 taser incidents that have led to someone either dying or suffering serious bodily injury just in 2020 and 2021. And LASD itself reported 11 such incidents. I think it's important to clarify that in those incidents, tasers were not always the only use of force used. And so it is not immediately clear from the data that the serious bodily injury resulted from the use of a taser. However, there are a few incidents where the taser was the only use of force used. The injury that's noted is internal injury, possibly, you'll see later, some sort of cardiac injury. And that is noted in several of the taser incidents that is included in that 11 number. So I think it's fair to assume that taser may have led to serious bodily injury to someone's organs in those cases. But that data is also, I think, helpful to illustrate when tasers are used by LASD and when they are causing serious injury. In 8 out of 11 incidents, so the vast majority, the person was unarmed. And in the majority of incidents, the person was reported to have a mental disability or impairment. And I think that data is important to illustrate that tasers are not de-escalating situations that might properly be de-escalated. So the warnings you see up on this slide are Taser's own warnings, the manufacturer Axon. And as you can see, there are quite a few uses that are known to cause or contribute to sudden death as the result of a cardiac injury. Some are a little bit intuitive, used against people who have heart conditions or who are elderly, but it includes like people who have been physically struggling or who are agitated, which includes a lot of people who are encountered in crisis. Shooting in the chest can cause death, sudden death, repeated use, so more than one shocking, or use lasting more than 15 seconds, and we know that unfortunately, tasers are used in these last 2 ways, or these last 3 ways with some frequency. There is also great risk resulting from falls because of the paralyzing impact of tasers. And so people who are restrained or handcuffed, as they often are in like a custody setting, are at risk of being seriously injured because if they're tased, and then there are a number of other examples here. I didn't do a comprehensive review of LASD's taser policies. That's not my focus today, but I do want to flag that not all of these are prohibited uses in LASD's policies. Some of them are just sort of noted as possible dangers that should be monitored after the use of tasers. Next slide, please. And so unfortunately, as I mentioned, the use of tasers has led to people being killed by law enforcement here in our own community. most recently Keenan Anderson, who was killed by LAPD, and Eric Briseno, who was killed by LASD. And so I think it's important, since I've been invited to speak about the community perspective, to uplift the demands that have been raised by the impacted families. So Keenan Anderson's family, along with Black Lives Matter LA, has called for restricting the use of tasers and emphasizing that less lethal does not mean that tasers are non-lethal, as we saw tragically in that case, to remove law enforcement from traffic and mental health response. The Briseno family has called for accountability for deputies who use excessive force, including with tasers. And the last point I just want to flag is that I know that LASD has asked in this budgeting cycle for more funding for tasers for custody staff, and community organizations in LA County are asking that the county not provide that funding, and instead look to holding officers accountable for excessive force and decarceration instead. Next slide. So there are a lot of alternatives to reliance on tasers that I think that the department should focus on instead. One, as I mentioned already, is decarceration. If deputies feel like their only use to handle mental health crisis in the jails is the only recourse they have is tasers, then perhaps we shouldn't be having people receive mental health care in the jails at all. We should be focusing on diverting people into community-based services and treatment. And so that also comes with increased investment in mental health treatment resources and crisis intervention. In the field, as well as in the custody setting, deputies can also, rather than first turning to a taser, rely on de-escalation skills that state law already mandates they're trained on. And here I just want to flag a really disturbing development that I've noticed, including in LASD's taser policy, which is the equivalence between tasers and de-escalation, or any less lethal force and de-escalation. Increasingly, we are hearing law enforcement departments, including this department, draw an equivalence there that is totally inappropriate. The definition of de-escalation and the purpose of de-escalation is the avoidance of use of force. And so if you are using force, especially force that could result in someone dying, that is certainly not de-escalation. And that's not what's included in de-escalation training. De-escalation training focuses on communication, use of time, space. Use of force is, again, just not de-escalation. And I think that's especially important to note with tasers, because one of the natural reactions that people have to tasers is that they will flail and scream. And that's just like an understood physical fact. Unfortunately, that can lead officers to saying, stop resisting, or using further force in reaction to that natural response. And so I think that really illustrates how, in many cases, use of a taser can actually escalate a situation. And I think the most important way to avoid reliance on tasers to respond to mental health crises is to divert mental health crisis calls in the first instance away from LASD to the extent possible. And I know that this commission may not see it as within their purview to be looking at those alternative crisis responses. However, I would urge you to recognize that dispatch is controlled by LASD. Who gets sent to a call is determined by dispatch. And based on my most recent communications with the county, there is no comprehensive LASD decision tree. There's no infrastructure set up for appropriate diversion to mental health crisis responders, even as the county is building up those alternative responses. So I think that's the natural next step to look at dispatch seriously if we're considering alternatives to tasers. Thank you.
I also want to thank commission staff. I want to thank commission staff, Nene Petrosian and Tracy Jordan, for their work on the forthcoming report by the committee and for the arranging of today's witnesses, which include Sergeant Michael Mabee, who is joining us from the LASD. As I mentioned, he is the Custody Training Standards Bureau Sergeant, and he will be issuing a verbal report today. Sergeant Mabee.
My name is Michael Mabee, and I am a sergeant assigned to Custody Training and Standards Bureau Horse Training Unit. Joined today by my Captain Thomas Looney, Training Bureau Captain Pat McDonald, Training Bureau Lieutenant John Haynes, and Lieutenant Jeff Chadwick, Dietrich's over here, Jeff Chadwick, who oversees the department's body-worn camera unit. My experience with the taser began in 2006, where I was first trained on its proper use. I became a post-certified force instructor in 2008, taser instructor for the first time in 2009. This past January, I received my master's certification from Axon Enterprise, the creator of the taser. Our unit certifies every recently sworn-in deputy in the use of the taser and creates taser instructors who return to their units of assignment to recertify deputy personnel every year. Our certification process uses Axon Enterprise's curriculum. Policies are guided by the recommendations while remaining within the parameters of our own force policies. As you may have read from our policies, the taser is a less lethal handheld electronic immobilization device used for controlling assaultive high-risk persons. Its purpose is to facilitate a safe and effective response to situations to minimize injury to suspects and deputies. Currently, the department primarily uses the model X26P, which discharges 2 probes from a single cartridge. If those 2 probes are effective, they will deliver 0.0012 amperes. I apologize, I struggle with that word, or 1.2 milliamps through less than 2,000 volts of current over the course of 19 pulses per second for 5 seconds. In comparison, the standard wall outlet uses 120 continuous volts to deliver 15 amps or 15,000 milliamps. Static shock from a doorknob is 35,000 to 100,000 volts. According to OSHA, 50 to 150 milliamps can cause respiratory arrest, and 1 to 4.3 amps can cause rhythmic pumping action of the heart to cease. The goal of these pulses is to overstimulate the motor and sensory nervous systems, causing neuromuscular incapacitation, uncontrollable muscle contractions, or NMI. Therefore, depending on certain factors, taser is designed to disrupt voluntary control of the muscles. This may cause the person's body to lock up, during which time deputies are encouraged to secure the subject in an effort to prevent further uses of force and potential injury to the subject and personnel. Deputies are trained to be aware of these situations and to make decisions based on the information available to them at that time. The department is committed to preservation of life, force prevention principles, including de-escalation, holding personnel accountable when force is employed. Like any other weapon, the taser is only to be used when objectively reasonable to do so and in compliance with our policies and training. When used appropriately, it has the potential to minimize injury to both subject and deputy. We train our deputies to understand and respect these responsibilities that they have when using this and any other. Every use of force, including those where a taser is utilized, is investigated administratively. Learn from those encounters and hold deputies accountable when those responsibilities are not. We welcome any questions you may have about the devices, our policies, and our training. Thank you.
Sergeant Mabee. Speakers here today. Chair Kennedy. Commissioner comments and public comments. Thank you.
We should go into commissioner questions. Rob?
Or maybe, and also Ms. Wong, but well, for Ms. Wong, apparently there have been 1,000 deaths nationwide. Like, over what period of time are we talking about? How many?
So the Reuters investigation that that's based on is from, I think, the first taser death that they were able to find, which was in 1980 to 2017.
1983 to 2017. Okay, thank you. That's helpful. The question I wanted to ask Sergeant is, if you know, tasers are a less lethal use of force, obviously, wondering, is there any data on what's have been saved because tasers have been used on certain lethal from a Ma'am, look, I'm asking the questions here, all right? If you have a comment, there's public comment. Look, I'm asking a question. Please do not interrupt me, all right? All right, I'm
Listen.
asking a question, you know, and if you don't, I would ask you to supply the commission staff with the response to my question next meeting. Do you know?
We're going to get to everyone. Everyone's going to get a chance to weigh in or ask a question. It's just a matter of time.
Thank you for the question. It's a great question. As far as comparing to if further force could have been used versus with the force that was used, such as the taser, I'm not aware of that existence. I know that we are looking towards documenting how we use it, including in free force type incidents where it is a mitigating factor. And hopefully, as we move forward and look at those things, we as LASD would have that answer for you.
Solely for LASD would be great to have that response. That's a very small data set. But I'm wondering if there's also any nationwide data. So if you take a look at that for us and provide us with any information you can for the next meeting, appreciate it. Thank you.
Thank you.
I'm not familiar with tasers. I've seen one, you know, for dogs because I had an incident, so I did purchase the little civilian one. But do you have a picture of what you use, and can you comment on the difference between what the public buy and what you use as a professional? Yes.
For the commission, we're also in the process of trying to put together a presentation by Axon. Just trying to marry our calendar with your calendar.
So this first one here, ma'am, is the X26P. It's what the department currently uses. We piloted and we have a few of these Taser 7s out to different stations and within our custody facility. We're trying to see if this is something that would work well for us. The difference between the two is this one allows you to shoot or discharge 2 probes. This one allows you to discharge up to 4 probes, so you can target, let's say if the first attempt did not work or was unsuccessful, you have the ability to try again. We are looking at what's known as the Taser 10. It's brand new. It's only been out for about 3 months. We're going to be piloting that hopefully in the near future. That has the ability to, instead of, these probes come out at a set angle. So if I'm this far away, I might be able to get a preferred targeting area, be able to engage that NMI effectively. But if he's wearing a thick jacket, I'm probably not going to be able to that jacket. The Taser 10 gives you 10 individual probes. I can select an area. So there was some concern about the chest area being targeted before. Taser does not. The chest area can engage the thighs, which have large muscle mass, and probably be a more effective area to target. Not more power, actually less power. So something you'll commonly hear is 50,000 volts. In actuality, it's less than 2,000. What volts does is it's the pressure to bridge the gap between the probe that's inside the cartridge to the skin. So if it didn't go through a jacket or a layer of clothing, it would try to jump about 2 inches to the skin in order to affect that circuit. That makes sense? With the, drops down to less than 2,000. The Taser 10, it actually goes down to less than 1,000 volts. And again, it's the amps, not the volts, but with the 10, I can target the areas that would be most effective. Okay? Does that answer your question, ma'am?
Yes.
Thank you.
Now, black, so
Yeah, what you're looking at is exactly the way it's displayed is in yellow. This version, the X26, was in black. To your point as well, as far as confusion is concerned, LASD policy acts on recommendation, and now state law says that it shall be carried on the dominant side of the body, opposite the firearm.
Sergeant, I had a training question. I know you mentioned that, generally speaking, trained how to administer the taser and use it. But what about specific training as it relates to those who you suffering from mental illness and or under the influence of drugs? Has there been like research done within the department to talk about how tasers can affect someone that's either mentally ill or on drugs like cocaine or some other kind of drug?
As far as research on the department, I'm not particularly sure about that. However, each sworn deputy, when they come to the academy, they receive a 32-hour block of instruction on how to communicate with people in mental health crisis, as well as those under the influence of controlled substances.
But is there a specific training about using a taser against a person that you believe might be intoxicated, as opposed to just general training on a taser no matter what?
Yeah, it's part of the 8-hour certification course is identifying people that be in those types of situations and then using that to gauge whether or not it would be the most appropriate response.
Any independent training about how tasing can affect someone that's on drugs and how that could lead to their death?
It's just something, again, to be aware of when you're using it, and that's true of anybody, whether or not you're having a mental health crisis or under the influence.
I have a training question also. If we know that the use of taser might contribute to sudden death, especially being shot in the chest, does the training try to avoid? Do you train folks to aim for the thigh or arm and not aim for the chest?
Correct. Yes. So with these versions that we just talked about, and we can talk about the Taser 10 next, which is, again, to try and play, to use, the desired areas are actually going to be towards the back, splitting what we call splitting the belt line, going below the waist into the thigh area. We want to try and get as much muscle mass as we can. Chest, stomach, abdomen area, not as much muscle mass. If that is solely the only that's available and the deputies feel that this is the only opportunity I have in order to employ this, it is available to them. However, again, it's not desired. And what we'll train to do is look for lower thighs. With Taser 10, you can select that area. So you can select, I want to hit both thighs. Run that current across that way. Locks up those muscle groups, that individual will fall to the ground. And catch themselves, yes.
When, for the training in the deputy trained in the use of a firearm, where, if predominantly then, what is the target on the human body if you're, a deputy is using a firearm? Is that like, would it be the chest area that would be because it's the larger part of the body? How does that work? What do you focus on? Assuming you want to hit the person and be successful in hitting them.
Correct. This is Lieutenant John Haynes, who's the lieutenant over Training Bureau, who does our academy training.
Good morning. In a situation with a firearm, we train to shoot center mass.
Center mass?
Center mass, yes.
That is, what does that mean?
That would be towards the center of the body.
So that is the chest area?
Yes.
Okay.
Yes.
Okay, so in one instance, you're trained to go to this part of the body. In
Correct.
the other instance, you're trained not to use, to use a taser,
It's gonna
to
be
not do that.
Yes, depending on what tool or what less than lethal weapon you're using.
Thank you.
have a question.
Thank you, you. Just to follow up with Vice Chair Hicks, I think we're all very concerned about increased use of fentanyl in our communities, and has there been any type of study or analysis on how someone under the influence of fentanyl could be affected if tased, if you know? I've also one follow-up question on, I've heard it anecdotally that there have been situations where a taser has been used, it's been ineffective, and it ultimately, and I'm not speaking of the LASD, but I've just heard nationwide, and because of the ineffective nature of the taser application, they had to go then to a lethal use of force. And I've heard that some folks have said that the reason the taser was ineffective is it had been the force of the taser had been dialed back, if you will, because there was concerns about lawsuits. Is this just an old wives' tale, a myth, or is there any truth to that?
I guess to kind of clarify, when you say dialed back, you mean be able to adjust what comes out of the taser?
Well, it wasn't that the individual department or officer had that ability, but the Taser International had made a conscious choice to bring it down a click or two. Because you're saying now this A10, I believe you're talking about, is in fact coming down in the amount of power. So I'm a little confused on how it's going to still be effective if it's putting out, from what I read, instead of 2,000 volts down to 1,000.
Yeah.
How that's still going to be effective. Because the idea is to incapacitate someone so we don't have to use lethal force. And if it's not going to work, then wouldn't seem like a good idea to even go there. And I share Commissioner Giggans' concern. I mean, it does seem we train one way for the firearm as far as a target area and another way with a taser. I can see where in the heat of a conflict, these could get confused, which one they're supposed to be using at that given time. I asked multiple questions. I apologize for that.
I'll try and track with you, sir. Yes.
All right, thanks.
So I guess to begin with, as far as dialing back voltage, again, the voltage is simply to make sure that that connection occurs. So it might start at 50,000 because there is that gap. Once it obtains that connection, it will drop down to less than 2,000. And that's with the current platforms that we're using. As far as dropping down to 1,000 with the Taser 10, there's a little bit more velocity. I believe it goes about 30 feet per second faster than the other ones. There's a change in the probe technology. It also gives us 45 feet versus the current 25 feet. So when you talk about Commissioner Bonner with how can we track instances where lethal force could have been used, this is an instance where if we're 30 feet or 40 feet away from an individual, that time and distance that was also discussed, we can increase that, potentially use that taser in order to end that situation without escalating to lethal force. The 1,000 volts again is, did I lose it? 1,000 volts again is just simply to bridge that gap, to get the amps inside the body, that pulse inside the body, to create that NMI. And personally, as someone who experienced the X26, and I thought it worked very well, I experienced the Taser 10 in Las Vegas this January, and I can tell you it also works very, very well. Did I hit everything, or did I? All of them? Okay.
Yeah, I think.
Thank you, sir.
Anyone? I just have one question. I recently reviewed a DA memo declining to prosecute a deputy who had tasered someone 4 times, who was handcuffed and had made false statements in a report justifying the last tasering. And I'm talking about the Hunziker memo. And I was wondering, are there any limits on the number of times deputies can taser a person? Because we heard from the ACLU that multiple use is something that can be deadly. And 4 times seemed like a lot to me, but I don't know this world like you do. And so I was wondering, does the department like have limits? I mean, that gentleman was handcuffed.
That particular incident, I would have to review it to give specific comment on. How as far as number of activations of the taser during a situation, I would like to tell you less is more. What we train is what we talked about in the introduction. Once that taser is activated, and the hope is NMI is achieved. So the person goes down towards the ground and they're incapacitated or their muscles are locked up. If that person is alone, there's different considerations. So if that person's alone, they're going to be giving verbal commands. Hey, when this is over with, put your hands behind your back or put your hands out to their side. They're going to be giving them something to gauge their compliance. If they have partners or even just one partner, they can tell that partner, hey, this is going to be off in 2 seconds, 3 seconds. We're going to try and secure that individual while they're still under power. They're still locked up under NMI. As far as 3, 4, 5 activations, goes all the way back to the reasonableness. That person is going to have to articulate why each additional activation was warranted. And they might be able to do that. I'm alone in the middle of the night. This person has a knife or another weapon. They're telling me that as soon as they get up, they're going to attack me. So I'm going to keep this person under power until additional personnel can get here. As far as a person that's handcuffed, it's forbidden in our policy. We do not tase handcuff individuals. But again, without reviewing that particular case, I wouldn't be able to comment on that one.
So the case just prompted the question, which is there a limit? Like, and the answer is, there's no specific limit.
There's no, again, it goes back to the reasonableness. Why am I using the second round, the third round, the fourth dose? I'm an advocate of ineffective force has the appearance of excessive force. So it could be that 2, 3, 4 pulls of the trigger or the taser was activated 3, 4 times. It doesn't necessarily mean that that person experienced the effects of the taser. The clothing could pull away, a probe could have been broken off, or the wire could have been broken off. So while it's activating, it's actually not delivering the voltage and the experience that it's supposed to be experienced.
Thank you.
Thank you.
Yeah, Sean, if I could follow up on what you were just talking about. I know in looking at that same incident, I had some concerns that, and I don't know if this is possible technically or not, but I hope it will at least be discussed with Axon and you would give it some consideration. That I know there's a point where when deputies are involved in uses of force, suddenly things take on a life of their own. And I would hope there would be some mechanism where the deputy's brain could catch up with their finger. And by that, I mean, I think this is a situation where they were using it, they may have been using it appropriately, there may have been total justification, but there was a point where things just got out of control because we are human beings, deputies are human beings, and suddenly this trigger's being activated for, I believe it was 29 seconds, which I think by anybody's definition is probably not appropriate in the fact that this device could keep going for that length of time without a forced stop to give everybody a chance to go, let's reassess what's going on here. Because I'm with you, if you've had to use a taser 4 or 5 times, I think you're going to be looking at this isn't effective. It is not working. We need to go to another force option. But if there was some way this machine could force that thought process to begin to say, you know, this isn't working and I can't just lay on this trigger for 29 seconds when you know that it's just not working. That would be something I think it would benefit the public, it would benefit everyone. So I got to say, I don't know if that's technically possible, but it's something I would hopefully be discussed with Axon, at least the department would consider looking into that.
So with the current versions, things that you'd be looking for and listening for if you have a successful activation is the person reacts to it. They go down to the ground or that side of the body becomes immobilized, but generally they'll go down to the ground. You're also listening for a change in the tempo of the electricity from the device. But which can be very hard when you have auditory exclusion or there's people yelling and screaming, you're giving verbal commands. So with the TASER 10, First of all, there is no drive stun mode. Not going to see an arcing of electricity coming from the front of the device anymore. You're not going to hear that clicking to kind of give you that analysis. What you're going to hear instead is a loud tone, and that will tell the user that you have successful bridge between the positive and the negative probes. So that would help. As far as turning itself off, they have batteries that will shut off the activation at the 5-second mark. But to your point, I can pull it again and start another 5 seconds. Yes, sir.
Okay, why don't we take public?
Good question. So in terms of policy and practice, and when a MET team goes, when say for instance a DMH clinician is paired with a deputy and they roll out to a mental health crisis, how are those, is there like a criteria of when the deputy would use the taser that would, I guess when, if you have the clinician that can see and probably understand what's going on, but is there, if it's like if the individuals start approaching the deputy or the clinician, then would the taser be used?
I'm sure the MET team would be better able to speak on their particular situations they might have encountered. Our policy states that it shall not be used unless the person is hostile or violent. So in the particular case of in patrol with a clinician and they're going to be assaulted, the deputy has lots of choices. But since he's now responsible for this clinician and their safety, the taser might be the better application. OC spray might be an appropriate response, or maybe our control techniques. It just all depends again on the situation at hand.
Is that it? Oh, okay.
Now I'm intrigued with MET teams using tasers, because I know in our inquiries with our ad hoc committee on MET, that's nothing, that's never come before us in terms as a tactic for MET. So maybe we can, I don't know if somebody knows that that is used by MET, or we can find out if that is in the skill set of de-escalation with the MET team.
Our MET teams don't normally deploy tasers. It's not their function. It's normally a patrol side function. So if you have deputy personnel respond to an incident, they're normally equipped with those less than lethal weapons. And so when MET team is called to that particular situation, the MET team along with deputies are there to de-escalate the situation. If the situation turns into something where the suspect becomes hostile, then the deputies will step in and use whatever tools they need in regards to stop the problem. So that's what we're looking at there. So
May I add something? So the Office of Inspector General did do a report on the probation department's taser policy, and some of those things are relevant here. So for instance, in our report, our recommendation is to use tasers in lethal situations, which would then go to what Commissioner Bonner said, which is that you're using it to save a life. When the situation is less than lethal, our recommendation is that a taser not be used. So because it is less lethal, but it can be lethal. So our recommendations to the probation department included that particular recommendation. So it really should be used to avoid using a gun.
And one last question. With Sergeant Mabee being here and with your lengthy experience of 15 years in training, I wanted to ask, what has been changed in the training protocols in your 15-year tenure as a trainer on taser devices? What changes have you incorporated into your training? And what are the top lines that you might identify for us here in this rare and blessed opportunity we have for discussion of this. What changes have you helped incorporate into the training over that 15-year period?
Well, first of all, I appreciate that I would have any type of impact. We do follow Axon's training guidelines. We follow their lesson plan. We incorporate our policies and procedures and our use of force tactics within those, but the bulk of the information is theirs. As far as what I've seen from my first encounter in 2006, my first instructor certification in 2009 until present day, is we incorporate a lot more practical application of it. We'll put the instructors and the students through scenarios that engage them in thinking about what options that they have available to them, and then proper use of that taser. And in some of the instances, they get put into it, and kind of a training scar would be, I'm in a taser class, I'm probably supposed to use the taser in this scenario, but it's just not there. It wouldn't be the appropriate response. And that's really the goal of that particular scenario that we put them in, where they go, even though I'm in this class and it's probably expected of me, a more appropriate response might be to continue to talk, to use an OC spray, or, unfortunately, in some of the scenarios, to use a firearm.
Okay, start with public comment, because I think we have some people who want to weigh in.
Yes, we have 7 speakers signed up for public comment. Our first speaker, Isaac Asbury, followed by Ron Dow, followed by Michelle Infante.
Good morning. Just going to be real quick about this. I've been working with this commission from day one. I take my hat off to you guys, but you guys have pushed it as far as you can push it, as far as I'm concerned, okay? So I'm going to be providing you a list of deputy-involved shootings of officers who we feel allege have been in multiple shootings, and we feel they are part of a gang. It's kind of long, so it's 10 pages. It's how many officers? 1,248 deputies have been involved in shootings. That's this, I present that to you. This is my tracking that I started with Mr. Kennedy back in the day. This is our officer-involved shooting that we do ourselves, right? Okay, it's complete. It goes all the way back to 2000. You'll have a copy of this. My biggest question right now, I'm not going to come back up here and talk to you about deputy-involved shootings. Who I'm looking for now is Operation Safe Streets. These type of officers, every time they're in a shooting, they don't provide their names. It's 159 names that I'm missing for our report to be complete, okay? That's that. So I won't be back up here talking about deputy gangs. And one thing I want to say, for all you guys, you take this list, right, and before you have these officers come up in here, you got to know who you bringing up in here. Because if we are in Compton, right? When this started, when they shot at Anthony Weber, I don't know if you remember, they shot him, they couldn't find a gun, they was ready to kill officers, okay? Kill them. But it's not my job to keep them sane, right? They could be looking at these cases that's coming up. It's not, now the problem I have is you got a good officer and you have shootings where you do have to shoot somebody, right? The ones I got has multiple shootings. You bring somebody up and talk about a goddamn taser, right? You ask him how many shootings have been involved in, okay? Ask him how many shootings have been involved in. That's just one person out of like 1,000, 1,500 people you bring up here. You bring somebody who's been in shootings.
Thank you, sir.
I'm not going to start. But anyway, you vet these people. If you come to Compton with this, you don't know who the hell you're bringing up here. You want to know how a taser feels, you're going to have to watch how guns feel, okay? And that's all I have to say on it.
Thank you.
This here is for you. I'm going to sit down. My next thing is takeovers in Compton, right? Every time we call the Compton station, they don't have enough police. We've lost 10 people to takeovers.
We're going to come to Compton for a town hall, and we're going to really dive in.
Our next speaker, Rondell, followed by Michelle Infante, followed by Helen Jones.
Good morning.
Morning.
And happy National Poetry Month. Compton College students hold "We Stank Breath" in a 2001 Pontiac Aztek. Sheriff's deputy creeping, black and white. Flashing red lights, their Crown Vics stopping steep. The ugly yellow Aztec, this cold night. Compton College students brimming, 5 deep. Burning clegg light, dirt crunches beneath boots. Eyes widen, students' heads bobble like dolls. Passing mongrel dogs, a white owl hoots. Lead cop unholsters, his nervous resolve. The Aztec turn signal winks, one red eye, as sweaty cops peering through windows tint, smoky weed, the burnt orange moon hangs high, a palm tree bends, bronze sway in a breeze thin, the trainee cop wavers, parkway muddy, a student's heart pounds, he needs to study. This is from this great collection called What's Uprise. Thank you.
Thank you.
Thank you. Our next speaker, Michelle Infante, followed by Helen Jones, followed by Yvette Correa.
Good morning. My name is Michelle Infante, and I would like to welcome everyone here. This is America. And in America, you get to stand next to a murderer. You get to be in front of someone who has ties to deputy gangs. And I would bet that every one of you, as long as you've been working, at some point in time, you've probably come across something that was bad and you did nothing. And you're sitting up here representing the department in front of families who've not lost their loved ones. Their loved ones have been killed. Maybe? No, I think so. It's for sure. And Mr. Bonner, I can appreciate who you are, but there are families out here that want to speak, and sometimes they may speak out of turn. You don't need to disrespect them. You could say something nicely. This was built for them, not for you and not for any one of you and none of you who've just gotten here. You don't understand none of the stuff that these people have been through. Nothing. And yet you come up here, you dictate how much time they should have when this belongs to them, not to anyone else. And you have the nerve to bring people up here who have murdered other people. People haven't lost their loved ones. And this is not a clique. And you know that because you wouldn't be wasting your time having town hall meetings all over the county of Los Angeles if it was deputy cliques. It's deputy gangs. They murder people. They murder people every day. They tase. And if you look like I did and my coworker Helen Jones at Autopsy Reports, very few of them will tell you that the people that are brought in that are dead have been tased. Do you want me to tell you why? Because people like these up here can't write honest, ethical, and moral investigation reports. So you want a percentage of how many people have died being tased? You're never going to get that. You want to know why? Because these people up here can't tell the truth and write an investigation report if their fucking life depended on it.
Thank you. Helen Jones, our next speaker, followed by Yvette Correa, followed by Raquel Derfler.
Thank you. Good morning. My name is Helen Jones. I am the mother of John Horton, who was beat to death and murdered by the 3,000 boy deputy sheriff gang members. And also these deputies are tattooed deputies. And I'm really sad to even know that April Tardy is sitting up here in the position that she is in and has a tattoo. So that is like a kick in the ass to me, my family, and every other family that has lost a family member. There are so many families, including my own, will never know our loved ones have been tased or not. And that's because people like Dr. Opal here the county coroner do cover the deputies' wrongdoing up in the sheriff department run, so we would never know how many times our family members has been tased or if they have been tased or not. We would never know that. And the only way we will know what tasers really look like, if y'all insist on them the next time they come back, that y'all should bring them back, that they should let us see what taser marks really look like. The ones they say that killed somebody, the ones that say that injured somebody. Have y'all asked that of them to show y'all what these taser marks look like? That's what y'all need to know. We need to know what that, because we really know that our family's been tased. Also, Juan Career been tased. But Dr. Opal, with the county coroner, said he wasn't tased. But we need to know what these taser marks look like. So y'all really need to make the sheriff department and insist that they bring something and put it up here so we would know what taser marks really look like. The taser that's injured the family members, the taser that's killed people, died from. We need to know the steps of what these taser marks look like, because they don't tell the truth. Even in my son's death, they staged his death to look like a suicide, beat to death, bust all his organs. Y'all know the story, everybody up here. But it is a shame what the sheriff department is getting away with, and tasing people and killing. And they know how to kill somebody. They know the death marks. They was trained to do this. Thank you.
Our next speaker, Yvette Correa, followed by Raquel Durfler, followed by Allende Love.
And I printed some articles about my brother Juan Correa, who died in Men's Central Jail on September 26, 2017, and his death was declared a natural death, but his body was returned to us full of bruises and blood coming out of his ear, nose. I saw a big green on his forehead. Even with all the makeup, I could see it, like they banged his head against something. The tasers that were used on my brother, they did not admit that. And it took a long time, many years, for us to finally see the pictures where taser marks had been used on my brother. So these reports need to be rewritten by Jackie Lacey and the coroner. Who is going to rewrite these reports? Do we need to exhume my brother's body as the mother's wish can be done? The sergeant who was in charge, these people in leadership, they have ink. My brother was on the 4,000 floor where the 4,000 boys are. He should not have been there. He had disabilities. They move people around, just like they did with John Horton and Jelani Lovett. So I can't wait to see how Jelani Lovett's case comes out, because it's the same thing that they did to my brother. Theirs was a lot worse. Luckily, there's video of my brother, and he was ignored when he raised his hand and let them know that he couldn't breathe. And they still declare it a natural death when the video proves that it was not a natural death. And these tasers are used prior days, so it's a long death, and it affects their hearts. So they're able to get away with it because in most of these cases, they link them to heart conditions. So yeah, of course, the taser exuberates those conditions, and they don't connect it. They just say, oh, it was their heart. Thank you.
Thank you.
Thank you. Our next speaker, Raquel Durfler, followed by Allende Love.
Good morning. I'm Raquel Durfler with Cancel the Contract. I am co-chair. Once again, we are hearing the department put on a dog and pony show to minimize the harm done by tasers. The ACLU just came up and told you people have been killed. Okay? They give you the data. And then here we have, I'm not sure of his name, to come up and compare it to putting your finger and getting like a little electrical shock, like it's not a big deal, right? He wouldn't really answer, is it acceptable to tase a handcuffed man 4 times? They can't ever answer. They give a non-answer answer. What's more incredible is actually Commissioner Bonner. Okay, you are tasked with being empathetic, with being understanding. You hold held to a higher standard. Of course the family members are going to have an outburst. It's emotional. Their family member was murdered. Just like I hold the police to a higher standard because they can kill me, I expect that of every commissioner. You hold it in, you be professional, you be respectful to these family members. I'm so upset, I'm shaking from what I saw. That's just what I want to say. Show empathy. That's your job. You chose to be here. You're not here to give a platform and try to agree with LASD to ask how many lives were saved. No, the question is how many lives were taken. Don't give them a platform to give their BS, covering their behinds. That's not what, as community, we're looking for all of you to do. Thank you.
Thank you.
Our final speaker, our final in-person speaker, Ayanda Love.
Hey, y'all. First, I just want to say I absolutely agree with the sentiments that everybody was saying about Mr. Bonner here. Highly disappointing. Please, if there's ever a time where you feel like there's something that you can't handle, don't be here. And I just want to say that to you man to man, because I'm extremely disappointed, and that was a female that you were speaking to just now. If there's an emotional situation that needs to be handled, then lead by example. Don't sit here and tit for tat with anybody inside of the crowd. That's just to start off with that portion. The second thing is reasonable according to who? For the tasers. When you say that, okay, if a chest is exposed or that's the only place that they can get to, then they have the jurisdiction to do so. In which case would that be unless you're talking about an amputee? Why would you not be able to reach another area of the body? Why would that not be the next immediate portion of the training? To say, hey, instead of saying we had to do this, which we know could result in the death of a person, are we not talking about people anymore? If we know that something can result in the death of a person, then the training needs to be centered around how to avoid that. Not how to say, okay, well, we couldn't reach another part. That's unreasonable. The approach itself, the reasoning itself is unreasonable. So then it goes back to according to whose reason? The people who just presented it in that nature? Or is it going to be a separate jurisdiction, or do we leave the police to police themselves yet again and have more and more cases like what they just brought up to see these same results again and again? Thank you guys for your time.
Thank you.
Thank you. And we do have 5 individuals who've signed up for public comment online. Leticia Vasquez, if you can acknowledge the request to be unmuted. Leticia Vasquez. Okay, Leticia, please go ahead with your comment.
Yes, hi. I'd rather speak about the autopsy.
Okay, we
when the
can go
agenda
ahead
comes
and
up.
save you for that item if you'd prefer.
Yes, please. Thank you.
Okay, thank you. And next, Tamra, you've been sent a request to unmute. Please go ahead. Tamra, I see that you're unmuted, but we don't hear you.
Can you hear me?
Yes, please go ahead.
Hello, can you hear me?
Yes, Tamara, we hear you now. Please don't touch your mute button and go ahead with your comment now.
Thank you. First off, I would like to thank the ACLU for the report. It's the only thing that made sense. We want all law enforcement out of traffic stops and mental health crises. This has been very disturbing and traumatizing to listen to, especially I can't imagine the families impacted listening to this. I am completely disturbed and traumatized hearing that y'all gave that deputy so much time to talk about the taser, and it was incredibly disturbing. The fact that Eileen Decker is sitting there and the other woman, I can't remember her name, talking about how they need more training and more money to change the culture. There is not enough money in the world, and no money in the world, how much money you throw at it can change this evil within these departments. Okay, we need to dismantle them and refocus our money back into the communities and Black and brown communities for housing, healthcare, mental health services. Keenan Anderson was killed by a taser. If you go by to the LAPD website, there is a report from 2021 on the use of force. I believe it's the Taser 7. Typically says that officers should only use them when their life is in danger, and they should be using them at a distance, not right on top of a person's body. They tased Keenan Anderson on back of his chest, on his heart, and back where his heart was for several minutes and killed the man. Stop calling them less than lethal when they're actually killing folks, right? And this commission is a disgrace. This is supposed to be a civilian oversight. You give more time to law enforcement than you do the community. Like, this was so disturbing, I can't even wrap my head around it.
Thank you, Tamara. That does conclude your time. And next is MJ King. Go ahead, MJ.
Thank you. I'd first like to give respect and gratitude to the families participating in this meeting. A reminder that tasing someone is not de-escalation. Less than lethal force is escalation. Communication, use of time, space, those are all de-escalation techniques. Force is escalation, period. Ask yourself what a taser that's effective from 15 to 25 feet is doing to a civilian who's being tased within a foot or holding it against their body, tasing them 6 to 7 times in a row. LASD is explaining taser use in respect to distance to their victim. That taser that they're describing is moving at 180 feet per second. That's 120 miles per hour. Now this taser 10 that can reach 45 feet is supposed to be 30 feet per second faster. That's 143 miles per hour at a person's center of mass. Instead of describing and showing pictures, why aren't these deputies demonstrating these tasers on themselves for you all to see the real life effects that a taser has on the body? They are aiming for the center of mass with military weapons, a weapon that's traveling 120 to 143 miles per hour. You are not using a taser to increase time and space. You are using a taser to escalate the situation. Instead of an increase of funding for tasers, the county's budget should be spent on decarceration efforts through diversion programs and funding community resources, not more military weapons. Investing in the community keeps us safe, not cops with military weapons. Thank you.
Thank you. And next we'll hear from Andres Kwan. Please go ahead with your comment, Andres.
Hello?
We hear you.
Can you hear me? Okay. Andres Kwan, ACLU SoCal. First off, we appreciate Commissioner Johnson's comments that we must call these tattooed illegal racist groups for what they are, deputy gangs. Second, we'll lift up the name of Ignacio Ochoa. It's imperative that the COC, that LAC personnel you called to the meeting, do you really think it's appropriate to host deputies involved in shooting and killing community members? Now, on this time on tasers, mainly we need to lift up that LAC has supposedly used tasers for years now, yet this has done nothing to curb LAC killing community members, including with tasers, a case in point being Eric Briseño's case. Even according to the coroner's report, Eric was killed from cardiopulmonary arrest due to neck compression and restraint with a taser. And his family has faced retaliation and harassment from deputies, as described during our Detective Sheriff Family Forum with Supervisor Solis and Mitchell in 2021. And this last point brings me to the community meeting you just hosted in East LA. Family after family spoke about the harassment they continue to face by deputies, including by those who kill their loved ones. And so we need to finally ensure the adoption of meaningful policies regarding family harassment and the proactive supervision needed to implement these policies. Lastly, I want to briefly address the OIG reports. On the body-worn camera report, it doesn't inspire confidence at all. For one, deputies have shot community members, but conveniently never activated their body-worn cameras. And Sheriff Luna's administration had proposed amendments to former Villanueva's horrendous policy, but these changes were never vetted by the OIG and the public. And so the final policy should be adopted only after a community process both informs and includes the public on how body-worn cameras could be used to promote accountability, but in particular also how we can limit potential negative impacts on civil rights and civil liberties. On the traffic stops report, we must remember that the vast majority of time spent on patrol is for traffic stops, and the LAC's primary function is a massive traffic enforcement enterprise with disparate and devastating impact on communities of color.
Thank you. And next we have on Adrienna Quinones. If you can acknowledge the unmute request. Okay, please go ahead, and you will be the last person for public comment on this item.
Yes, can you hear me?
We do. Please go ahead.
Good morning. My name is Adrienna Quinones from Hacienda Heights. And first of all, I want to thank the commissioners that were present on Saturday. And for those commissioners that did not attend, it really made the Brown community feel that you don't care about us. So shame on you. Sheriff Luna, missing in action. So the first thing that I want to say is not all deputies are bad and not all community members are good. Let's get that straight. I grew up in Boyle Heights and I got to see the best and worst of everything. There are times where tasers are needed. I have seen it myself when people are on their drugs and a deputy 2 and 3 cannot handle. So let's be real about that. I also would like the community to be included in decision making. You need to have an advisory committee within the commission. That has not happened. I would also like the commission to go out into the community and have town halls, but real town halls, where you sit at the table with community members, elected officials, and others. Together, we can make changes. But currently, the way it is not working. Thank you so much.
Is that it? Well, this was this proved to be, we thought it was going to be a hard topic, and it proved to be a hard topic. Emotions are high. I hear the people who talk about the conversation is disturbing and traumatizing to families, and I'm sorry, I just don't know how we're going to solve our problems unless we lay it all on the table and talk honestly with each other about what goes on when tasers are used. So we're just going to have to keep it up, and I appreciate the participation from everyone. We're going to take a 15-minute break and then take up autopsy reports and coroners.
And if everyone could begin making their way back to their seats, the break time is almost over, so we will resume shortly. For everyone who's logged online, thank you so much for joining us and staying tuned in. We'll be coming back from break shortly. Thank you.
We're going to start up again because we have another difficult but important topic to discuss. For a couple years now, this commission has been asking questions about the availability of autopsy reports to grieving families and the use of security holds to prohibit the release of autopsy reports, even though they are considered public records. And to that end, we have our medical examiner-coroner here, Dr. Ukpo, and we also have some folks from UCLA who are going to give us the long view. Our hope is that we can reach a solution so that people who had a family member who died because of a deputy shooting can get access to the autopsy report in a timely manner, and members of the sheriff's department can have time to investigate what they need to investigate. And so why don't we start off that discussion? We're going to begin with the coroner.
Thank you for inviting me to speak today.
Thank you for coming.
Absolutely. As you mentioned, autopsy reports are public record. There are circumstances where a security hold may be placed on a case to prevent release of information that may compromise the investigation for law enforcement to find the suspect, or the information may pose a threat to the community, and therefore a security hold can be placed. And these requests typically come from law enforcement. In August of 2020, a policy on security holds was developed in order to develop a uniformed approach to how we handle security hold requests that come to our office. And the policy involves the law enforcement making a formal request for a security hold, and that is submitted to our office for my review. And then I review the reasoning for the request for the security hold and either approve or deny that request. If the request is approved, there is a 6-month time frame where we will revisit the security hold to see if it is still indicated and needed. And if at that time, if there is information that's not provided that indicates that the security hold is still needed, it will be lifted. And also, if it's the request received from law enforcement is not sufficient enough to explain why a security hold is needed, it will be denied upfront, and so that case will not be on security hold. Currently, our department has 51 cases that are on security hold. They vary in their reasoning. However, the common thread is that they are homicides. And looking at the information of all 51 cases, the homicides have particular information that is sensitive and may compromise the investigation, given the unusual circumstances that the death had occurred. Of those on security hold, the death was due to law enforcement use of force. We have 0 cases in the security hold on that category. In addition, category of incarcerated or in custody deaths, we have 0 that are on security hold. Our current policies and practices for law enforcement to observe autopsies is that our practice in our office is to allow the investigating agency that is investigating the death to attend the autopsy upon request. A 2-hour notification is given to the law enforcement or whichever agency is investigating the death, a 2-hour notification to attend the autopsy on the same day. Attendees have included individuals in law enforcement, the DA's office, and also the Office of the Inspector General. And this has been a practice in our office, and the attendees are not allowed to instruct or direct any part of the examination. It is strictly a courtesy to provide information to the investigating agency for timely investigation on their end, because our autopsy reports can take sometimes 6 to 8 months to come back, given our backlog in toxicology. And this amount of time would not allow to share the information that is needed to lead to immediate either a pursuit of a suspect or arrest. And so the information that is shared early on at the earliest time possible is at the observation of the autopsy when the law enforcement is invited to, or rather their request to attend is received and accepted. And the time frame for cases that are not on security hold vary. It depends on the cause of death. So if the cause of death does not require toxicology testing to be done, which is currently taking 6 months, the report can be available in a shorter time, in a matter of weeks. However, toxicology testing is frequently part of the testing that we do in our office, and therefore many examinations come back 6 to 8 months after. And that includes homicides, that even though the cause of death may be a gunshot wound, toxicology is requested to provide information for the circumstances surrounding death. And so in that case, even though we have the cause of death the same day, the toxicology report will complete the entire report, which will be available 6 to 8 months after death. And I wanted to also address undetermined cases and what does that mean, and to define what it means when we say undetermined. There are 2 components of where you can see undetermined in our reports. One is in the cause of death. And in the cause of death, when we see determination as undetermined, it means that even after the autopsy, a toxicology report, and a review of the circumstances, we were not able to determine the cause of death in the individual. Another area where you would see undetermined in our cases is in the manner of death. And the manner of death is regarding the circumstances that led to death, and there are 5 different manners of death, one being natural, so like a heart attack, an accident, for example, a traffic accident or an overdose, There could be a suicide, and there could be a homicide with his a homicide case such as a gunshot wound or a stabbing. And then the last category is undetermined. And undetermined is a manner of death where either the circumstances are not very clear about how the death occurred, that we are unable to determine the manner of death. And one example would be if someone is found at the bottom of a cliff, there are many circumstances that this person could have been found there, and they could have been pushed, they could have jumped, it could have been they tripped and fell. And so those are, because the autopsy cannot distinguish between those circumstances, then in that one example, the manner of death will be undetermined. Another circumstance that you could see undetermined is if there's competing factors for death that all could have caused death in of themselves, but it's unclear given the circumstances and the competing causes of death that it can be said with certainty that this one caused death, but the other one did not. And so sometimes those competing factors are factors that could be homicide and an accident, a difference between an accident and a natural death. And so in those circumstances, that's where you would see undetermined for the manner of death. Thank you for this invitation, and those were the points that I wanted to discuss, but of course, happy to answer any questions.
Taking so long for toxicology test?
So toxicology testing is a very specialized testing that requires multiple rounds of testing to have absolute certainty that an agent caused the death. Versus in a hospital setting, toxicology can come back very quickly because it's done on urine, for example, and they just want to know if the person may have drugs or not. That's a very quick test, but the certainty that we have to stand by our standard is much higher than that. And so the testing that we do is on blood. And the blood, we have to detect it, but also measure it. The other complication is that when someone dies, blood is not in the usual state that it was when the person was alive, and so it creates complications of testing. So the proteins kind of stick together, and so it has there's technical challenges that are had with determining the agents in the blood. Also, the increase in multiple drugs being detected in our cases has increased. We don't see too many single drugs cases, and so each drug takes a long time to confirm itself. But with the advent of things like fentanyl being present, and in addition to methamphetamine and cocaine, we're seeing those more commonly. And so that also extends out our testing. And then the biggest factor perhaps is also staffing. Staffing is probably the biggest factor that we've had an increase in cases, a substantial increase in cases since the pandemic, approximately 3,000 more cases a year. And a lot of them are drug related. And so it has strained our staff, and we need to have increased staff. And training of the staff, it takes an extended period of time as well. It takes 6 to 7 months just to train someone to get up to speed. And our computer system is working on being upgraded, and that is also a factor that slows down our ability to turn over cases.
Tracking some of this stuff out if you have enough staff.
We are in the process of contracting at this moment, outsourcing our toxicology testing to help our in-house get caught up as a temporary solution. We continue to ask for, in the budget for positions, but also technology advances and et cetera.
We're gonna make time for everyone to weigh in or make their comment. We just need, okay. Right now, Rob, you have a question?
Yeah, questions. Clarifications mainly. We're primarily interested in autopsy reports with respect to either people that have died in custody, sheriff's custody, or deaths by use of force by law enforcement. And I think I understood you to say currently of the 51 security holds, none of them relate to custody deaths. And I think you also said, but I just wanted to clarify that none of the security holds, at least currently, relate to deaths that resulted by use of force by law enforcement. Is that correct, or did I misunderstand?
That's correct.
Any others?
Yes. Ukpo, I understood your testimony as being that attendees at autopsies are not allowed to instruct or inquire?
Direct.
Or direct. Does that mean that they are not allowed to speak?
No, it is information sharing with our office regarding the autopsy findings. That's what is shared with law enforcement.
And are you aware of the efforts ongoing in California to disaggregate coroner functions from sheriff's department functions, especially in larger counties in the state?
Yes, I'm aware of that initiative for coroner systems to be essentially abolished and to convert to medical examiner systems.
In your experience, have you had any of your staff, or have you ever observed personally, any efforts to steer or in any way interfere with the direction of an autopsy, or to in any way impair or obstruct what might be the unbiased findings of an autopsy?
I have not personally or seen it, witnessed it happen. Although our name of our office is Medical Examiner-Coroner, it's a misnomer. We actually function as a medical examiner's office. So we do our independent investigation to determine the cause and the manner of death.
Are you in receipt of any evidence indicating that there have been efforts to impair or to in any way redirect the findings of a medical examination? Is there any feedback that you or staff has observed that indicates any instance of that, or much less any pattern of that?
There hasn't been any pattern of that. However, because medical examiners are physicians, they all have their different approaches to examining a body. And sometimes there are procedures that one doctor does but one doesn't. So there may be a question about, okay, this doctor puts, a rod through the body, but this one doesn't, So there may be questions on that procedure, but the person always proceeds with how they do it. And that's how they're instructed to go, because they're not supposed to direct anything. It's just a sort of a question. So that's the only sort of thing that I've seen that's sort of a question posed, for a particular case. But otherwise, the law enforcement individuals stay about 6 to 8 feet away from the body. They're not around the physician while the autopsy is being conducted, and the physician then shares the information with them at conclusion.
Thank you. Would you be willing to come back to testify before this body if we were to invite you?
Yes, the same that I'm here. I'm happy to be here and to speak on this very important topic. So.
Doctor or Patty, did you want
to? Doctor, are you aware of the family assistance program that's been we've been working on this for about 4 or 5 years now, and it's been piloted, and I know it's in process of really coming to fruition. It's going to be housed at the Office of Violence Prevention. Are you aware of some of the challenges around communication from the coroner's department to the impacted families when they're trying to find information, how someone died, when they get information, when they can receive the body, in the state that the body is then released to the families? Are you up to snuff on all of that?
Yes, so communicating with the families there's various things involved. We have an investigation team that handles questions about the investigation whether it's property, where is this, or various things, but also how the body is now moving through our office, and is the person available for release. And so we do communicate with families that do reach out to us and say, when can we expect the autopsy to be done? When can the body be released? And we're able to answer the questions at that time. One of the challenges we have is with if it's pending several tests and we don't know the cause of death at the time, the same day that the call is made. And that is often due to toxicology still pending, so we can't really say very much. And so I'm aware of the families have challenges there with the toxicology results back. But we're always in communication with families that do reach out to us.
I have a question. We've been talking about taser injuries. Do you document taser injuries in your reports?
We document injuries in our report. The implement that caused the injury cannot always be determined. Now, a gunshot wound or a stab wound, you can tell, it's unequivocal. However, the markings on the body that may be imparted by a taser assumes that the skin was exposed, and so even when it is exposed and then the taser does touch the skin, it's a very pinpoint, very small injury. That is photographed. So we do document them, we do see them, but not with high frequency.
Doctor, you give a courtesy, as you said, to the Sheriff's Department to attend your autopsy. But my question is, in the deputy-involved shootings, many, if not all, are probably going to result in litigation in state and federal court where the department is actually a party to the case. And do you think it's appropriate for the independent coroner, which is tasked with providing a non-biased evaluation of the cause of death, to invite one party into the autopsy room to participate in some manner, but exclude the family of the dead person who is also a party? I mean, they're much more than a party, but I just wonder if the office has thought of that, because it seems kind of unfair to invite one side in when they're going to be a defendant, but exclude the other side when they're going to be a plaintiff.
And when you say the plaintiff is excluded, can I get clarification of who the plaintiff is requesting?
The family of the person who died in a deputy shooting.
To witness the autopsy?
Well, we just did a town hall on Saturday in East LA, and people talked about how bad they felt that the agency that had actually been responsible for shooting and killing their loved one was allowed in the autopsy, but they were not.
Well, I think that the investigating agency that investigates the shooting is invited to attend the autopsy in general, but this category of officer-involved shootings, where they are also invited, they are the investigating agency that is investigating the death.
But they're also a party.
Yeah, they are. And my question is then that as I mentioned before, the law enforcement is sort of in the background. They're not over the body. They're not telling us what to do or directing. And we have a very narrow scope of what we determine. We determine the cause and the manner of death in the individual. So we determine that independently. And so I think there's an opportunity to perhaps ask questions about, what actually happens, what does a medical examiner do, the scope of what they do, and understanding that, to see if there is any sort of compromise in any sort of investigation as a result of what we're sharing.
But are you concerned about the appearance of unfairness when one party, defendant department, gets to participate in the autopsy that's supposed to be neutral and another party doesn't. Plaintiffs who lost their loved one.
Yes, I do appreciate that. I have a concern about the optics of that, absolutely. Now, but there's also opportunity there to provide information about what we do as an office independently.
There's a cost too, because people feel like this isn't a fair process when the defendant department is there, but we're not allowed. You don't have to.
I want to invite our county counsel to answer a question on the legal aspects of this.
Good afternoon. I'm Brian Chu. I'm a principal deputy county counsel, county counsel's office. I provide the general counsel advice to the medical examiner-coroner's department. To your question about whether or not other members of the public or the family can participate in an autopsy examination, state law precludes that kind of participation. State law does provide for the investigating law enforcement agency to observe the autopsy examination, as well as any pathologist professionals who are doing scientific research, as well as any professionals who are undergoing any training in the subject. So beyond that state law, that is, to invite somebody outside of those categories would violate state law.
Could you just exclude everyone, to be fair? Just exclude everyone, because they're not just investigating, they're a party too.
Under state law, the investigating law enforcement agency is entitled to observe the autopsy report.
What's the law?
It's in the health and safety code.
You have the fact that they're allowed, does it mean that they have to be in there? Because they're also a party. They're not a traditional investigating agency in a deputy shooting. They have a stake in the litigation.
There is no published law that speaks to that particular issue. It speaks of the investigating law enforcement agency. And if the law enforcement agency that's investigating has a separate arm that performs investigations pertaining to internal reviews, that would be the appropriate arm of the department. It would not typically be, and it's not the practice that I know of, and I've been representing the department for the past 6 years, that the operations or anybody from the particular patrol station would be observing the examination. It's typically the homicide investigators or internal affairs.
But then we get homicide investigators take the Fifth Amendment at a coroner's inquest when they're asked about their investigation, and it just doesn't seem like an ordinary, traditional, independent investigation. It seems very problematic to have them in there.
Well, I'm not sure what you mean or are inferring with respect to the deputy's right to Fifth Amendment, because typically I've never heard of any deputy being allowed into an autopsy examination suite for observation.
I'm talking about the detectives investigating it, Andres Guardado, Miguel Vega, and Mike Davis, and Joe Valencia. They're investigating the shooting, and they took the Fifth Amendment at the coroner's inquest.
But they were not involved in the shooting itself.
Right.
Which is the reason why I was not the one who represented those detectives. They have their own separate legal counsel, and I cannot speak to that. But all of that would have been post examination. And so you're sort of looking into the future as to what a detective may intend to do in the future.
I understand your position, and, maybe we should just move on. It just seems terribly unfair to me. Anyone else?
Could I just say
And
one
one
thing?
more question. When the family hires their own coroner to examine the body, what is the process?
Dr. Ukpo.
When the family has a pathologist that they wish to have attend the autopsy, we acknowledge that request and allow them to do it. If they're able to find a pathologist that they would like, a professional to observe the autopsy, they are allowed to do so.
Time that you're doing.
Yeah, at the time that we're doing it, that the family can, if they can arrange it. Sometimes if they say, well, we can have them the next day, we'll try to accommodate them. But each day that passes compromises the body's state of condition to do an exam. So, but it is allowed.
Anyone else?
Can I just say, so the Office of Inspector General has been to some autopsies, so it's not the same exactly as a, truly independent party like we're speaking to in litigation, but we at least have the opportunity to be there. There is also a bill pending before the state legislature on police use of force, and I think that people who are interested in this should contact their state representative in the Assembly. It's Assembly Bill 807, and this bill would require the state to investigate all peace officer shootings resulting in the death of a civilian. So right now, the state investigates where the civilian who was killed was unarmed. This would require the state to investigate all cases regardless of whether the civilian was armed. So I would encourage people who feel strongly about this to contact their assembly member and ask them to support Assembly Bill 807.
Thank you. Well, why don't we, Doctor, I really appreciate you answering our questions. Why don't we hear from Professor Terence Keel, UCLA, who has some information for us as well.
Good afternoon. It's an honor to be here, although if I were to speak frankly, I wish I were here on other sets of circumstances, to be honest. So my name is Professor Terence Keel. I'm a professor at UCLA at the Institute for Society and Genetics in the Department of African American Studies. I have founded and directed a lab that has been investigating in-custody deaths, both here in California, Los Angeles, and many other counties across the United States. The report that I'm sharing with you has been a collaborative project with another research laboratory, the Carceral Ecologies Lab at UCLA, directed by Dr. Nicholas Shapiro, and the local social justice organization, Dignity and Power Now. What you're looking at here now is a summary of 2 reports. This is the first of 2 reports that were released in collaboration with my lab in the last year. This first report, we looked at deaths that took place within the Los Angeles County jail system. Now, the names and the cases for this report were provided to us by Dignity and Power Now, which submitted a Public Records Acts request to the Los Angeles County Medical Examiner-Coroner, asking for all autopsies of people who were killed between 2009 and 2019. They received 59 autopsies in response to their request. However, looking at data released by the Bureau of Justice Statistics, which is the statistical agency of the Department of Justice that gathers data concerning jail deaths, there were 260 total deaths reported from the county to the Bureau of Justice Statistics over this time period. From what we can gather, the cases were not made available as a result of security hole at the time that we were doing this investigation. I do want to add an additional caveat. The public interface provided by the Los Angeles Medical Examiner-Coroner does not provide a way for you to determine if an autopsy is or has ever been on security hold. So if an autopsy is on security hold, they just don't exist on the public. When we looked at these cases, we assess and analyze 3 types of documents that are included in these autopsies. This includes the medical examination that Dr. Ukpo explained. It also includes the coroner's investigative narrative. This is the really important detail, in that forensic investigators who do not have medical degrees are sent to the scene of death to interview deputies and jail staff if a death takes place inside of the county jail, to ascertain the details about what transpired prior, during, and after the cause of death. Those documents are included in the autopsy, and they're also made available to the medical examiner who's conducting the autopsy analysis. And then thirdly, we look at the toxicology reports. In our assessment, what we gathered from the 59 cases that we did have access to, as you can see in the demographic here, vast majority of the deaths that took place between this time period were of Black and Latino men. What we also saw is that, statistically speaking, the most populous category of death taking place in Los Angeles County Jail during this time period were natural deaths. However, when we looked at the average age of death across all of these cases, the average age of death was around 45, 46 years of age, which life expectancy of Americans is around 76.2 years of age. So we're talking about people who are dying around 30 years earlier than we would expect in the free population. As you can see in the graph, there's a large concentration of African Americans who are dying as a result of quote unquote natural causes at 17. We also see a large number of Latino populations who are dying both of natural causes, but also as a result of undetermined factors. Now, what I will say is that in this particular study, since we're looking at a jail environment, the undetermined death classification for us has been a bit confusing in that, as we all know, every aspect of an inmate's life is controlled by deputies and sheriffs. So this includes the water they drink, the air they breathe, the food that they eat, who they visit. So for us, the idea that there could be either unclear factors as to why people are dying seems a bit of a mystery to us. What we also want to just flag for your attention here is that in these 59 cases, more than 78% of the people who died before a standing trial. So these are people who died in pre-trial custody. Next slide, please. This is a second summary report that was published by my lab just recently, looking at deaths inside of Los Angeles County Jail in the year 2000. Reason why we looked at 2000 is that it was the most lethal year in Los Angeles County Jail before the COVID-19 pandemic, with 38 total deaths during this time period. For this report, we did not have access to the autopsies. For this report, we looked at the summary statistical data provided by the Bureau of Justice Statistics. We are in the process of acquiring the actual autopsies for these files. We are also in the process of acquiring the additional 201 autopsies that we did not have access to when our community partners made that request in the beginning of 2020. But what you can see here is that the statistics and the trends that we saw in that larger sample seem to also obtain in this sort of specific study of 2009. 71% of the deaths from this report occurred during pretrial. 70% of those pretrial deaths were of Black or Hispanic people, with men being in the vast majority of these particular cases. Again, also what was obtained, the average age of death for those natural deaths, which were the most populous deaths during this year, was 49 years of age, which again is significantly younger than we would expect of the free population. Final slide, please. And so in this assessment, I think there's a couple of things from my lab's perspective that we think would help solve this crisis of death within custody and within jails. Obviously, supporting increased efforts at decarceration and jail diversion programs. The way that we like to think about this in schools of public health is that these are deaths that are called excess deaths, deaths that could have been avoided if, in this particular context, these people were never in jail to begin with. Certainly that's true for those who were involved in pretrial. There are already and have been passed bills to allow greater access to prevent underreporting of in-custody death. There's been significant studies showing that law enforcement offices underreport in-custody deaths and that in-custody deaths are often misclassified. We believe that a revitalization of the Los Angeles County Medical Examiner's website that would allow families and communities and even this commission itself to look at the number of cases and files that were previously put on security code would allow for greater transparency. We also know that there are assembly bills that are asking jail facilities to report within 10 days when the individual died within jail, including the manner and cause of death, or at the very least, the demographic information. I think that type of detail would be extraordinarily useful for families and communities for us to curb this crisis in jail. And finally, quite frankly, the security hold practice, given from our perspective, seems to be a practice that has been abused historically here in Los Angeles County. So we would ask the commission to strongly consider eliminating the practice of using security hold for in-custody deaths. Thank you.
Thank you. Any commissioner questions for Professor Keel? Why don't we take public comment?
Well, no, I have a question. I was just sort of shocked that you never got the rest of those reports. Was that due because they were the whole cases?
We believe that those reports would not have made available to us because they were on security hold. Now, what I will say now is that those cases have been released from security hold, and we are in the process of acquiring those records from the Los Angeles County Medical Examiner-Coroner.
First speaker, Isaac Asbury, followed by Donald Harlan, followed by Yvette Correa.
I'd like to discuss takeovers in the city of Compton, right? We've been having problems with takeovers for the past 3 years. But in the last 2 years, we've lost 10 people. One is Raymond Stephen Barros, who's 24. Ricardo Rodriguez Aguilar, Michelle Gonzalez, Jennifer Flores, Michael Ferrillo, Jalen Kwok, Logan Stein, and Rondo Merce Diaz was hit by a LASD Sheriff police car. To this day, we don't have the name of the officer who killed him. Carlos Arias, Salvador Barbosa Jr. We need some help with these takeovers. When the residents call, they were saying that they don't have enough staff. They're on priority calls and the such. So it's now that the takeovers know that they're not going to have any enforcement. We had over 500 people just the last weekend, and now they're taking it to the next level, breaking into the stores that are on the corner. So that's a problem. It's kind of getting out of hand. Next is Compton homicide reports that we maintain. Make sure the sheriff gets this. We've had 508 killings as killer loose from 2023 to 2000 to 2023. We've lost 538 people, and that many killers are loose. Nobody has been apprehended in this case. So I would like to get this to sheriff. This is just the Compton station on. Last but not least, plan to invite Mr. Sean Kennedy, the Black National Criminal Justice in Birmingham, coming up in July as one of our speakers. That's it. Thank you.
Thank you.
Next speaker, Donald Harlan, followed by Yvette Correa, followed by Michelle Infante.
Hi, I'm Donald Harlan. This is concerning the problems with dilemmas with the coroner office. You see, I have family members who were murdered by LA County sheriffs that I haven't got the coroner reports for that I'm trying to retrieve. There was an attempt to cover it up. There was an attempt to replace my family members rather than I'm unable to access the coroner reports. If there is an autopsy report or a coroner report, I would like to see it before you release it, but they have to be released. My family members were killed or they're dead, they have to release the bodies or the coroner reports either way. I would suggest to the coroner's office that they use forensic exams on the family members who die, especially if they're signed up for organ donation. It seems that the county and the sheriffs are in a situation where they've separated family members, separated kids from their families, and those people that they set up as foster parents are signing them up for organ donation and making deals for them, that they need to do a forensic exam when they release the coroner reports or give information or provide body parts for people selling them. Also, another thing the coroner needs to know is that the police are weaponizing the killings they're doing. The police will show in their police report or the video that they killed somebody, and then you're going to find out that they're not dead, that they gave them a new identity, that they're hiding them from the law enforcement that killed them, and that they're going to move them into the neighborhood where that police officer killed them, or that police officer lives, or their kids are going to school, that they're weaponizing the murders the police are doing, that nobody's safe, that you guys are going to have a lot of problems.
Thank you.
Our next speaker, Yvette Correa, followed by Michelle Infante, followed by Arthur Callaway.
Regarding autopsy reports, we were also speaking about the tasers, so I want to finish touching upon that a little bit because it's related to my brother's death as well. Why are we using tasers on nonviolent people, on inmates that don't have any history of being problems, of being a problem, of somebody that's supposed to be in Twin Towers because he has a disability, he collects Social Security. And so they're using these tasers because in the street they can use a gun and shoot you, but in jail they can't do that because then it'll be more obvious, so they're using these tasers. And if you don't do what they want fast enough, they use it on you. So that's not the way you should use tasers. So my brother shouldn't have been subject to tasers because he was not a problem inmate. And why does the coroner report only have a detective Valencia? Who is this detective? Does he have ink? I want to know who he is. Why didn't they mention the doctor? The doctor that signed off, that was fired after giving them the okay to put my brother in general population so that they can have a reason to let him die. They want you to die. They didn't like him for some reason, so that's why they put him over there. And you know, he raised his hand, letting them know he couldn't breathe, and they just ignore you, and they write these reports that say the story they want you to hear and forget to put all the doctors' statements. And the person who was not allowed to give my brother air also. My mother said that he was standing by and the sheriffs did not allow him to help my brother. And the second autopsies reports are also compromised because there's a lot of corruption out there. So, you know, my mother just couldn't, she had to give up because there was so much fraud out there, they get rid of the evidence. So she's like, all I can do is hope they exhume his body someday. You know, all these reports are false. Even if you get a second report, they're able to, you know, get that person to falsify it as well. They have a lot of power.
Thank you.
Our next speaker, Michelle Infante, followed by Arthur Callaway.
Defibrillators are used to shock people back to life. So you guys think about what they're doing to somebody who's alive and their heart is working, okay? In terms of the county coroner, let's think about this. The sheriff's department creates the lie and then writes it on paper. And then what they do is hand the lie over to the county coroner. And then the coroner is supposed to believe what the sheriff's department is writing. So now we have another lie that's been perpetuated by someone else. And who's the people that have the advantage? The county board of supervisors, because the very person that's sitting over here, right, he made a mistake in one of his autopsies, and I found it. And it was 2 hematomas on someone's head who had been killed by law enforcement. But what was written in the autopsy was that the sheriff's department said that when they pulled him off the bed, he bumped his head. So I had to ask the question, well, what if he didn't fall off the bed? And what if he was injured and assaulted by a deputy? Is that possible? And they said yes. And I said, well, why isn't that written in there? And I remember they got up and left the room. Now, if that's a possibility, why are we only writing one possibility in an autopsy report? Why shouldn't there be 2 views about what could happen? Because it's not one thing that happened. They start from the very beginning. We have the sheriff's department who wrote the lie. And now we have somebody who perpetuates it. And the people who have the advantage are the county board of supervisors, because the coroner is only accountable to the county board of supervisors, right? So who's going to make them do the right thing? It's not going to be the county. It's not going to be the supervisors. Why would they do that when they're the ones that put a price on someone's body when they've been injured or killed by law enforcement? So don't you think that there's a conflict of interest? Don't any of you think about that when you listen to this stuff? Like, all these adults are up here and you keep asking the same questions. You keep hearing the same people out here crying over and over again. And organizations like ours who are looking for money to help these people with therapy, because these people and some of the other people that are up here keep making mistakes. So we're helping try to fix those mistakes. I don't know why we're doing that. We shouldn't have to be doing that. People should be doing the right thing. And you should think about what these people are saying when they come up here. There's only one side. They tell their side. It's the sheriff's side. But there's 2 sides to everything. So those 2 sides should be written in that autopsy. And you should be looking at those autopsies. You should be paying attention to what Dr. Keel said. And you should also be paying attention to what Helen Jones said about her case and her son.
My brother was very strong, healthy, 31-year-old. And for them to say in the reports, he could have died the same way had he been gardening. The video clearly shows he was not gardening. He was raising his hand because he couldn't breathe.
Thank you. Next public comment, Arthur Calloway.
So I just have a quick question because I am to the process. It's obviously that this medical examiner, whatever the office is called, there's a direct conflict of interest for sheriffs providing the story at which they use to do an analysis. It's obviously a conflict of interest that the family is not allowed in there to provide their story that can be included in the report. Is it an ability, and like I said, I'm ignorant, y'all might already have this in process, to just recommend to enforce a new policy? I mean, if it is a policy that they are allowed to cops in for a cop shooting, shouldn't it just be as easy as a thing to go to LA County Board of Supervisors and say, hey, new policy, if it's a cop shooting, no one's allowed? And how about we fix the problem and say, there doesn't need to be a cop report used to make an analysis of the body in the first place. So you can just analyze the body. Yes, there was a contusion on the head, without saying from the cops that they fell out of a bed to cause that contusion. Is there any ability for the commission to be able to just recommend enacting a new policy, something that we can make an anchor so that we can actually get real change versus just, like, I'm not saying y'all do nothing, I'm just saying, like, can we do that like today or something?
Thank you.
We have one more public comment, Helen Jones.
I just want to get back to the point, the autopsy report with my son, John Horton. Listening to Dr. Opal talk about undetermined deaths. That's what my son went from suicide to undetermined. So once you take suicide, his death was ruled as a suicide with the 3,000 boys beating him to death. Then from the coroner department, his death was changed from suicide to undetermined. All his organs was busted, liver, kidney, hitting the head, flashlight therapy, broken nose. You can see his injuries. I'm talking about busted muscle in his back, and it was turned undetermined. Dr. Opal was privy to a meeting that I was in when I was told in front of Dr. Opal as a witness that my son was murdered. And he witnessed this. And it's something, this is what we saying is we can't get the truth brought up. It's being done behind closed doors. Then when we try to bring these people, you know, in front of everybody for the truth can be told. And Dr. Opal is a witness to my son being told that my son was murdered, right, Dr. Opal? Career was my witness too. And you know this. And that is sad that we have to go through this as families. But this is what we go through. My son been dead for 14 years. March the 30th made 14 years. Do you know how it feels to be a mother of a murdered child of the deputy sheriff gang, and then everybody looking the other way for 14 years? I know none one of y'all can even fathom what that feel like. And then to sit up here and look at April Tardy that got a tattoo, deputy gang on her, tattoo on her ankle, and get to be in the position that she in.
Thank you.
It's a disgrace to all of us. It really is. And y'all really do need to look into these undetermined deaths, because this is wrong that we have to go through this.
Thank you. And we do have 3 individuals online who have signed up for public comment. First, we'll hear from Elizabeth. You are unmuted. Please go ahead, Elizabeth.
Can you hear me?
We do.
Okay. Good. Yeah, good afternoon. My name is it's Ellie. I'm also an impacted family member. My cousin Junior Rodriguez was killed. Not in LA County. He was killed. He was 14. He was killed in Santa Ana. However, I've been also documenting use of force murders by law enforcement in LA County. So we have data going back to 2000, not just with the sheriffs, but all law enforcement agencies. And I'm actually glad that Dr. Opal is there, because the coroner's office has actually been one of our biggest obstacles in getting this data. First and foremost, starting with the cost of the reports. I personally have paid for my family members' report, somebody that was killed in LA County. Almost 2 years ago, I paid for this, and I still haven't received it. I've sent emails and haven't received anything. Then, Dr. Opal also said that the coroner, that currently there are no security holds by law enforcement killings on those cases. But some in the data that we have, we're also looking at the coroner stuff, and there's cases, coroner's cases, and reports that have just been disappeared. Most of those have been for people that were killed by tasers. So we have like the coroner's case number, but those cases are nowhere to be found. There's also a lot of limitations with the coroner's data, including race. They only indicate one race. So there's lack of data on biracial people. Same goes for the assigned sex. There's no information on transgender people who have been killed by law enforcement. And the last limitation that I want to share is that on some of the causes of death, it indicates that the death was caused by law enforcement restraint, either by carotid chokehold or taser. Sometimes it doesn't. So there's no consistency on that. So
thank you, Ellie.
yeah, I'll
And
leave it
I'll
up to that.
encourage you to email us at the commission for some of your questions if you'd like to follow up with us. The next public comment will come from Tamra. Please go ahead.
Yes, it's unacceptable that these families are being cut off, that have been impacted. It's unacceptable that Miss Jones, John Horton's mother, has been fighting for justice for 14 years, and there's been zero accountability. When all the evidence is presented to you that John was beaten to death in Men's Central, and the fact that these autopsy reports and the narratives y'all create through the sheriff's department, coroner, are all working in cahoots to, write their own narrative, when we know the opposite is true. There needs to be truly independent investigations. outside of law enforcement because they will kill our folks in custody, out of custody. Andres Guardado, Anthony Vargas, Paul Rea, Johnny Lovett. In all these cases, you know, they write their own narratives after they've murdered the loved ones of these families. And, you know, this is completely unacceptable. Y'all acknowledge there's deputy gangs. We passed Measure A. We also need a measure for deputy accountability, not just the head sheriff. It's acceptable that 71% of in-custody deaths were pre-trial. They're black and brown. This is a modern day plantation. Security holes are put on autopsies that they're not counted as public records. There's not accurate counts. All this is disgusting and unacceptable. This commission is not a true reflection of a civilian oversight because none of the families and the people impacted are on this board. And y'all continue to work with law enforcement and give them way too much time in these public meetings. The families are continually cut off. They need to be put in the forefront. And this just needs to be abolished. And again, Keenan Anderson, let's talk about him. He was in a traffic accident that needed help, and y'all take the LAPD take to death.
The last public comment will come from Leticia Vasquez. You're unmuted. Please go ahead.
Hey, thank you, everybody. First and foremost, I want to say thank you to Mr. Kennedy for expressing in regards to the autopsies. And I second everything that's been said by Horton and everyone else that just spoke. The fact that allowing detectives and officers and or internal affairs to be witnessing an autopsy is appalling to me. My son was murdered on October 6, 2019 by the Pico Rivera Sheriff Station officers. And we were never told when there would be doing an autopsy. So we never had the chance to take our own if we wanted them to witness this, but they were. And the fact that my son's body was vulnerable, it was there, it was raw. They got to see this. And to me, it's like giving them the opportunity to laugh, giving them the opportunity to cahoot. They can persuade a coroner. They can do a lot of things. In the statement of the autopsy, I get to see that they reported the statement and changed the facts of what happened. He broke his skull. There's a lot of things that happened to him. He got shot in the head. And they're allowed to see all of this. Even if they're investigating, what good does it do for them to be there? What is the purpose of them being present at the autopsy? What good does it do? They're not forensic. They're not doctors. They're not specialists. They do not know what the coroners and forensic people know. So why are they there? And why are we not given the chance to be there? Like Infante said, and Kennedy said, there's two sides to the story. Why can't we be there if they're there? What law is there? I want to know what the law is. And even if the attorney said that there was, he didn't quote any law. And it's nothing specific. So why should they be there? Why? They abused and mutilated and murdered my son all over again, and every one of our sons. They have taken advantage of every body that has been there and done whatever they wanted with that body. And they could.
That concludes our public comment.
Well, this is another really tough topic that I think we've only begun to exhaust. So maybe we can think about the things that we have been told today and continue this discussion. I want to thank the coroner and Professor Keel for being here and giving the information to us, and I really want to thank the families who spoke out to us. But we have one more agenda item, and it's important to a lot of people in the room, so I'm just going to move on to the president.
Before we move on, I do want to make one point that I wish that Dr. Opu were still in the room at the conclusion of this item. But I did want to note in his testimony, he stated that it was the custom of his office to grant the request for invitation when there is a request to appear at autopsies. And I want to put it on the record that it is possible to refuse that request for appearance, just as a note for follow-up on this point before we move on.
Thank you, Hans. The doctor had to go testify in court. That's why he had to leave.
I understand.
We're going to move on to the presence of deputies in the school. We have a report from the Office of Inspector General about this issue, and we have some members of the department here here to field questions. So, Dara, I'm going to turn it over to you. You can stay there if you like. You want to see? Yes.
Hello, I'm Dara Williams. I'm the Chief Deputy Inspector General with the Office of Inspector General, and I'm reporting on our report on school climate and safety, which is about school resource deputies. When I was mentioning bringing my phone up here, I did not do this statistical analysis. Someone in our office did. I didn't write the report, but was involved in editing it. And so if there's a math-based question, I will ask for Mr. Soltero to be unmuted to assist with that. So to start off, first I have to know how to work. Okay. So in June 2022, after we did a report on school resource deputies, the board asked us to do a broader report to look at the data from all of the schools. We had originally done Antelope Valley based on an incident in Antelope Valley, and we then looked at what we call the schools inside Lancaster and the schools outside Lancaster to make some comparisons. But you can also look at each of the school districts. When I say each of the school districts, you can look at the racial disparities for the inside Lancaster schools and outside Lancaster schools independently as well. So in response to this motion, the Office of Inspector General did this report. So in order to analyze the data, what we did was we looked at the school resource deputy, that's what SRD stands for. We looked at the contact data from the Sheriff's Department computer-aided dispatch system, referred to as CAD. And then we also looked at the discipline and demographic data from the California Department of Education for all the schools in the school districts under contract with the Sheriff's Department for SRD services. So these are all the schools in LA County that contract with the Sheriff's Department for school resource deputies. For the purposes of this report, the schools were reviewed, were separated into two groups. The first group is 76 schools from 15 school districts, staffed by 33 school resource deputies from 11 different patrol stations, and those are referred to as the schools outside of Lancaster. And just so everyone knows, this report was attached to the agenda. So all of this information is contained in our report. This is a summary. The second group of schools consisted of 40 schools in 3 school districts, staffed by 18 school resource deputies from the Lancaster station, and are referred to as the Lancaster schools. During the 2019-2020 school year, which is the data that we looked at, the Sheriff's Department provided SRD services to 116 schools total, 18 school districts, and 12 patrol stations. These schools consist of elementary, middle, high school, and continuation schools, as well as 1 adult school. We reviewed 15,640 CAD system entries by the Sheriff's Department and filtered this data to identify 812 school contacts with students by SRDs. The way that data was filtered was essentially to look for the age of the people arrested and also the proximity to a school. So that's how we arrived at the 812 school contacts. One thing that people may find concerning is that there were 21 contacts with elementary school age children. There is a chart on the back that identifies the contacts. The contacts for those children were for mental health and for assaultive behavior. We have not looked at the reporting incident information with regard to those, so we cannot at this point say whether those contacts were reasonable or not reasonable. We don't know if if there were attempts to get other people to the scene, or whether the school resource deputies was the first point of contact. We don't know why school district personnel couldn't deal with an assault when a 7-year-old was involved. But I think we can all agree that it's concerning that there were 21 elementary school age contacts. There were also 166 contacts of middle school age children, 11 through 14, and I think we can all agree that there's some differences between an 11-year-old and a 14-year-old. In other words, a 6th grader versus an 8th grader. I think that there's a substantial amount of maturity from 6th to 8th grade, and so I still think that the lower aged middle school contacts are something that we really need to look at. We have also requested that data. I think it's very likely there will be a follow-up report to discuss those contacts. This was not what we were looking at when we did this report. I was really surprised that there were elementary school contacts when I read this. And what was noticeable, the reason I think I even noticed it was it was one of the top 5 schools districts for racial disparities was listed as an elementary school district. But keep in mind that an elementary school district includes elementary and middle schools as well. But that was what piqued our it put our antennae up, shall we say, when we noticed that going through. The other thing is that of the 1,812 school contacts in which SRDs indicated they referred a student to a diversion program, it was only 2 instances of kids being referred to a diversion program. So we'll get to the statistics on cites and arrests and things of that nature. All right, so. In the schools outside of Lancaster, SRDs contacted Black and Hispanic students more than any other racial group. Black and Hispanic students were contacted at a rate disproportionately higher in comparison to their respective percentage of school enrollment. In the Lancaster schools, only Black students were contacted at a rate disproportionately higher in comparison to their percentage of school enrollment. And the degree of disproportionality of Black student contacts was much higher in the Lancaster schools than what was observed in the schools outside of Lancaster. Here is the data for the schools outside of Lancaster. The population is for enrollment for Hispanic youth is 70%, and they were contacted, 74% of the contacts were for Hispanic students. For Black students, they are 8.5% of enrollment, and the contacts were 18.3%. As you can see, white students were contacted less than their percentage of enrollment, as were Asian. The others and other students who couldn't be identified. So, and all of these charts are in our report. Now, the Lancaster schools, as you can see, the Black student enrollment is 23%, and the contacts are 59%. Hispanic student enrollment is 60%, and actually lower percentage of contacts than their enrollment. And then once again, you see that for white students, it's a lower percentage as well. In the 5 school districts with the highest number of school resource deputy contacts, Black students were disproportionately contacted in 4 of the 5 school districts. So what we're seeing here is really the biggest racial disparity when it comes to Black students. Most, as I indicated, in Lancaster. Outside of Lancaster, it's both Black and Hispanic. These are the 5 school districts with the greatest percentage of disproportionate deputy contacts: Antelope Valley Union High, Paramount Unified, Lancaster Elementary, that was my red flag, Roland Unified, and ABC Unified. So, and as you can see, 2 of those are Lancaster schools and 3 of those are outside of Lancaster. So we see the disproportionality in both school districts. It's just that Lancaster schools, it's a higher rate of disproportionality for both students. So now we look at arrest and citations. And once again, for the schools outside of Lancaster, Black and Hispanic students were subject to arrest and citation at a disproportionately higher rate in comparison to their respective enrollment. In the Lancaster schools, only Black students were disproportionately arrested and cited. In the Lancaster schools, that was 3.5 times greater than the disparity observed in the schools outside of Lancaster. In one school district serviced by Lancaster school resource deputies, Black students were arrested more than 86% of the time that they were contacted by a school resource deputy. So what that means is that when school resource deputies contacted Black students at this particular school district, they were arrested 86% of the time. And then here's the arrest and citation percentages at each school. So you can see that outside of Lancaster, there's a very high rate of arrest and citation for African American students. And as I indicated, these charts are all in our. So the issue of disproportionate arrest is even more pronounced in the Antelope Valley Union High School District. Antelope Valley Union High School District alone counted for 93.9% of all arrests made by school resource deputies in the Lancaster schools. So as I indicated before, that overall it was over 86%. But in that particular school district, it was even higher. The other thing that our report revealed is that there are inaccuracies in the CAD system, and that many times the deputies would code something as an observation arrest, but in fact it was a call for service by school staff. So we're surmising that the disconnect here is that a regular call for service is a citizen calls in a call, that gets coded as a call for service, and the deputy responds. However, when school administration is making that call for service, which might not be a 911 call, they're coding that as an observation, but in fact it's not an observation. They were called there by the school district personnel. And so we looked at some of the data to try to see if we can reconcile whether that was happening. And our theory is that what was happening, and based on the data, that seems to support the theory. So a review of the narrative sections identified at least an additional 311 of the 812 calls should have been classified as calls for service, right? So, and this is important just because we do want to address the interface between the school and the school resource deputies. And you'll see later that we have some recommendations along those lines. And then so that reclassification for those 311 are broken down then to the schools outside of Lancaster, 77, and the Lancaster schools, at least 234. So 58% of the calls in our estimation, based on the best data we have available, should have been classified as calls for service. So our recommendation is that the Sheriff's Department should take steps to ensure that SRDs properly memorialize the reason for their contact with students, and that will include the accuracy of the CAD system data. And it will also help the Sheriff's Department track whether SRD contacts are initiated by school administrators in order to try to have training for everyone involved to make sure that school resource deputies are not overused and are certainly not overused based on race. Discipline. This is school discipline, but since the data was available statewide, we also looked at this data. Black students were disproportionately suspended, and their suspension rates in school resource deputy contact schools exceeded statewide averages. In both of the schools outside of Lancaster and the Lancaster schools, Black students were expelled at disproportionately higher rates than their percentage of school enrollment. They were suspended and expelled at higher rates, as I said, than their percentage of school enrollment. So not just expelled, but also suspended. And the degree of disproportionality observed in the Lancaster schools was greater than what was observed in the schools outside of Lancaster. So that's consistent with the other results, that we see the most disproportionality for Black students in the Lancaster schools. In the schools outside of Lancaster, the 8.4 suspension rate for Black students was 3 times greater than the second highest suspension rate of 2.6% for Hispanic students. In the Lancaster schools, the 12.5% suspension rate for Black students was 4 times greater than the second highest suspension rate of 3.2% for Hispanic students. And then this is just a chart, once again, to show the suspensions versus enrollment. For Black students, they're 8.5% of enrollment and 25% of suspensions. For Hispanic, it's 70% and 63% of the suspensions. And once again, for white students, it's a lower percentage than their percentage of enrollment. That's for schools outside of Lancaster. For the Lancaster schools, as you can see, once again, there's a greater degree of disproportionality. Black students are 23% of enrollment, but 53%, almost 54% of the suspensions. This is just a chart showing the disproportionality. The other important factor is that suspension rate of Black students in SRD contact schools exceed the statewide averages. The suspension rate of Black students exceeded the statewide average by an average of 1.6%. It's a much lower percentage for Hispanic students at 0.1%. But exceeding the statewide average for Black students. And then this is just the chart with the differences. Expulsions. Expulsions are much less common nowadays than suspensions. I think they were used much more frequently in the past, but there are still expulsions, and we analyzed the data for schools outside of Lancaster and the Lancaster schools and found that Black students were expelled at a disproportionately higher rates than their percentage of school enrollments. I believe I previously said this, but this shows the actual statistics. Once again, outside of Lancaster, 8.5%, 32% of the expulsions, and then Lancaster, 23%, and account for 50% of the expulsions. So the Office of Inspector General does now review the SRD school contracts, but at this juncture, they're really boilerplate contracts with the names of each school put into them, and there are not a lot of specifications about the relationship or when school resource deputies should be summoned. Sometimes they are on campus, but if they were on campus and saw something, that would be an observation. So that might be understandable. But what we want to make sure is that the contracts contain specific guidance as to the types of situations when students should be referred to school resource deputies, what type of services SRDs must provide when contacted, and how SRDs should interact with school administrators. The contracts don't contain any information, any details with regarding. So our recommendations, sorry, I don't know how to, is to make sure that the effects of potential school-based bias, or in this case, actual, it's not potential because we've shown that it's, I mean, can't say it's explicit bias, but I think the data is fairly obvious that there's at least implicit bias, and that we need to make recommendations to try to remedy that. There should be a clear definition of the roles and responsibilities of the school resource deputy, the school district, and the school site, including a detailed plan outlining a process for student referrals to SRDs. We did make a request for MOUs. Our understanding is that at least one school district entered into an MOU, but my recollection is that we were not able to find that actual MOU when asked for it, which I believe we asked the Sheriff's Department for that. The extent to which information will be shared between the school district and the Sheriff's Department should be consistent with state and federal laws. There should be requirements for qualifications and training of SRDs. For instance, it would be a good idea to have SRDs receive the same training that MET receives, and that maybe some additional specialized training for school resource deputies. And then there should also be a system to monitor SRD performance that is available to the public. In order to facilitate the preparation of these reports, the Sheriff's Department should publish CAD system statistics on all SRD contacts. As you know, we had to ask for this information, but if this information were readily available, anybody could do the data analysis. And it would also be something that instead of asking for it from the Sheriff's Department, it would be readily available to the Office of Inspector General to look at that data on a regular basis. And the Sheriff's Department should also track and publish data on how many school resource deputy contacts resulted in uses of force on students and the level of force used. There is an assembly bill, Section 1299. There was actually a really great assembly bill, and that whole thing got scrapped. And so I took it out of this report. That was very specific about what these relationships with the school should be, and how school resource deputies should and should not interact with students. But AB 1299 does have prohibitions on behavior of school resource deputies. So no handcuffing on school campus unless necessary to address a violent situation, a prohibition on the issuance of a vehicle citation to a current pupil or any person operating a vehicle on a school campus, prohibition on the use of pepper spray at a school campus, and the prohibition of using a school resource officer or any police officer or law enforcement official acting as a school resource officer for purposes of correcting pupil behavior. And so obviously our concern with the elementary school children is that's what's happening, is that the school resource deputy is being brought in to correct behavior, which is really what the school administrator should be doing, not having a deputy contact a 7-year-old. So that's it.
Thank you. Do you have any commissioner questions?
Yes, I have a question.
Patty? To you.
I guess this being a Black mother myself and had my son go through public school systems, I am aware. So the data wasn't surprising. But in your recommendations, I did not see inclusion of parents. I feel it's important when the sheriff's department and the school administrators meet, that information also should involve parents, or that information should be shared with parents.
Thank you. I think we were focused more on the Sheriff's Department than the schools, only because we're not oversight for the schools, right? So I don't disagree that there should be parent involvement, and I do know that some of the individuals here are very involved in Lancaster in trying to make that happen. And the other thing is you have school board involvement, and so oftentimes the school board wants the school resource deputies, and sometimes the parents don't want the school resource deputies. And so, you know, we can't recommend that there not be school resource deputies if the schools ultimately want them. I mean, I guess we could recommend it, but we only have oversight of the sheriff's department, not of the county schools.
It's a very thorough and a good report. Thank you.
Hi. Yeah, not surprising, but extraordinarily disturbing once again. So I'm interested in how the school, and I know you don't have any authority over the school, but in your inquiry, how the school utilizes the resource deputies for correcting behavior. Is that common? Is that just been a practice that's been there for a long time because whatever reason they feel overwhelmed, they need to intimidate more, they're trying to intimidate the kids more by bringing in the officer. Can you just say a little bit more about that?
For those of us old enough to know, that's the $64,000 question. We don't know, right? So that's why there should be at least MOUs between the school and the sheriff's department so that it's set, there's a set policy on when a school resource deputy is used and when the school district needs to take responsibility and address behavior by school administrators and not by school resource deputies. So, and also the assembly bill. But our report also does discuss that, you know, MOUs, or better yet, have it in the school resource deputy contracts in the first place. So that's our main recommendation, is put it in the school resource deputy contracts. And we could say, OIG could say, we don't approve these contracts without that. However, we're sort of advisory. Ultimately, the board votes on whether or not to approve these contracts. But our advisement at this point is that these things should be in the contract from this point. I think they get renewed yearly. It might be every 3 years, but I think that what happened last time was that it was sort of a short time period. So if I'm not mistaken, we asked that they come up for renewal in a year. And we'd like to see these things added to the school resource deputy contracts now so that we essentially build an MOU into the contract.
We have some members of the department who look like they want to say something.
Yes, sir.
Go ahead.
Good afternoon. My name's Jeff Diedrich, and I'm the captain of Community Partnerships Bureau. And I also oversee our MET team, our Homeless Outreach Services team, our community-oriented policing teams, and different things, so it's quite comprehensive. This may be a unique moment in time where we agree with every recommendation you just said. There's no ambiguity here. It's also important to note that school resource deputies do not take part in discipline. That's not our role. Our role is law enforcement only. And so we do not take part in that discipline. We're not a part of that process. And I do believe if it needs to be clarified further, that we need to take those steps. We're very thankful for this process. One, it was new to me as being a unit commander, although I've been in the Bureau a while, seeing the different things that we do. It was new in the sense that we found out that during this process, that we were able to identify deficiencies, as Deputy Chief said, that there were deficiencies in the way our data was kept. As a patrol deputy, it's important that we log every contact, and that's the department's really pushed that strongly. Every contact needs to be logged. So what we found was our school resource deputies were logging these contacts, and it looked like an observation, because when we saw the numbers too, it was concerning. But their contacts, we found out that the majority, and we'll be working hand in hand with you to see what the future is and where the data is, because that data was 2019 to 2020, is seeing that where it is now. And where I was going was they were so keen on logging the contact that we were missing the fact that it was actually at the direction of school personnel. And so I asked, what's the difference between if a deputy says, I'm going to stop Mr. Kennedy versus Ms. Tardy told me to stop Mr. Kennedy. And so most of the contacts, if not, it won't be all, but most are at the direction of our school personnel. So as we look at the new data set, and because of this process, we believe we've corrected it. There's a million things, and Sergeant Morad Kambanjian is standing next to me. He'll address if you have any further questions, but every single recommendation that was up there, we've implemented. There's still things that are going through the chain of command to be reviewed by our new executive staff. The training, which we were blessed to just have last week, and maybe he'll talk about it, the MET training is already included. The crisis stabilization and de-escalation training that to me is the national model, it was the first class taught during last week's training with our school resource deputies. We also addressed some of the points from 217 brought up by the board of not having training for deputies with understanding the adolescent brain. That class was a 4-hour class taught last week. So the training and all the things without taking too much of your time has been addressed. There are current processes. What we found is that nobody knew it. And as a new unit commander, I didn't know some of these things. There's different stat codes, there's a manual, there's all kinds of programmatic things. We'll be responsive to your questions, but I'll stop there and answer any questions that you might have.
Any more questions? It's getting late. We have some people from Lancaster, I know.
I just want to say very plainly that this report is an alarm bell that all of us and our communities need to take seriously. I am very grateful to the OIG for compiling this report and for responding so forthrightly to the Board of Supervisors' 2 motions in this regard. But this sounds alarm bells for all of us. And I'm thankful for the presence here today, the extraordinary presence of people from the Antelope Valley who are here today in part because of a desire to make a family impact statement. And by that chance, we have some of the greatest resident expertise in the Antelope Valley here today to hear and take back this report, which is only a coincidence of that expertise being in the room with us today, in the person of Arthur Callaway, in the person of Raquel Derfler, and of the impact statements that they have brought before this commission today. This raises alarms about the process that is not in place, with all respect to the uniformed members of the department here today, that is not in place for any review of the SROs in our schools. And with the pattern of racist policing going on in the arresting of people and in the incident that we heard from Palmdale earlier today, a pattern and a culture of arresting young Black men in the school context and then in the community context, and that being normalized to the point where it deadens and tries to dampen any follow-up or complaint about that process or getting information about that transparently rendered. I want to ask if we can follow up on this alarm bell about the likelihood that given the abundance of contacts with African-American families and African-American young men in particular, when we have instances where SROs themselves are in schools of family members who have experienced police brutality or abuse themselves, there has to be some process of accountability for raising complaints about that presence and the likelihood that we're going to have SROs in the schools of relatives and family members of people who've experienced abuse. And we cannot leave the hands of school administrators tied in those instances where there's a complaint raised by a parent or family member about that presence of an SRO in a school, and we cannot revert back to the discretion of the officers themselves about whether they transfer themselves out of a context like that. I want to be clear that what we have experienced is, in the absence of administrative rules, in the absence of policies or best practices, and the failure to implement anything that resembles oversight in this context, we are left with officers themselves having a discretion to remove themselves when there has been a complaint of that gravity raised by a family member of someone facing an officer in their school or in their child's school who they've had previous contact with in the case of reported and documented abuse. So I want to be clear about what we are facing in the fallout from the absence of rules and policies and implementation. And I want to, on the behalf of the commission at least, to say, I take this seriously. I think we need to take this seriously, and I want to act in the aftermath of this alarming report.
Comment? We have some public comment. Let's take some public comment.
Yeah.
Oh, I'm sorry, I didn't see you is all.
Thank you for thank you for that present or distinction. Captain. So with regards to my question is, pointed out the distinction of school initiated actions towards, in a school setting as opposed to a school resource deputy initiated contact. In hearing this report, and I'm speaking from the schools outside of Lancaster, and in particular, the school district where I reside in this county, I've been in discussions with a school board member in the Whittier Union High School District. And there has been a number of students on the school side that have been caught with drug paraphernalia influence and are being considered kind of a fast track to expel. Some of the pushback from the community is that it's not so much the school resource deputy, it's the inability of the school administration and the school board to figure out alternative ways to keep that student in school, whether it's getting treatment, whether it's getting some kind of diversion action. So I guess my question is there data that is broken down that captures that, like district is?
When you say data that captures what, sir? That captures, we don't take part in the expulsion process.
Yeah, not so much this.
And that's a misnomer. A lot of people feel that we do. We do not. We're not a part of that.
So I guess my question with the data would be on your end, you're capturing one end. I guess what if I heard correctly, it was the data, being able to be clear on the data where it's school initiated as opposed to the law enforcement.
Yes.
Collection. That's where I guess we need to go to have a report that can look at that school district and see how many times the school administrators initiated something, because that brings a concern to school, their end.
Right. I think there's many paths to go down going forward. We're willing to go down with. I think that as you ask those questions, it'll open other doors too. Because I asked a question because I found there was data where a deputy had made a traffic stop at like 2 o'clock in the morning on a Sunday, but the school address was used because that's where they were. Did that get put into this data set that we were even looking at? So we thought there's a million things that need to happen here. And I think that with all the new things that you definitely, there's more work to be done on a future report back based on all the things that we won't have time to get to today. But I agree with you, and there's a need for that.
If I could just speak to one thing, I believe that we certain hours in this. I don't think we did the 2 o'clock in the morning thing. And then also the other thing, I think that's the biggest missing piece, is that I do think that school resource deputies are being used for school discipline. That's my belief. However, so the way to remedy that is to have contracts where the school resource deputies can say, no, that is not my job. My job is to engage when there's essentially criminal behavior, perhaps a fight, which might be mutual combat, so questionable whether that would actually be criminal. But in those circumstances, that's when you would expect a school resource deputy to act, but not just when an administrator is having a problem with the student, right? Students screaming at a teacher and swearing at a teacher, is that student behavior, or is that something you call a school resource deputy for? My opinion, that's something the school administration should deal with. And just for the record, my daughter's a high school teacher, and I still believe that.
We need to move to public comment. We have some people traveled here. We're already past time, so can we start?
Our first speaker is Raquel Durfler, followed by Racine Ector, followed by Vanessa Perez.
Okay, hello again. So I'm going to give you all a chance to ask me questions since I am from the Antelope Valley and I have information and knowledge about the Lancaster School District. So I'd like to open it up to any of the commissioners if they have questions about resource officers and not be timed because I have something else to say.
Well,
Okay.
we may continue this conversation in a
Okay,
later
great.
meeting.
So let me just say that the data that we have collected from 2021, 2022 does show the same disparities. So there is no change. I'm not quite sure why they feel that these things are not happening. And yes, school resource officers are being used for student discipline where I am. But I want to address like the issue of the reason that the school boards have these officers in the first place is for, quote, the feeling of safety that it gives them. And the biggest thing we hear about is school shootings. Like we need them there because what if there's a school shooting? So let me just explain that Robb Elementary in Uvalde showed that to be a false narrative because 376 law enforcement were unable to stop the slaughter of 19 fourth graders and 2 teachers. So that is not true. But let's talk about the, what does this do to students that are actually being targeted by SROs? Do they feel safe? Where is their safety? So where is the safety for a student who is body slammed by a school resource officer? Where is her safety when there's 2 administrators standing right there knowing that she is a special needs student? Where is her safety when a grown man is allowed to wrap his legs around this young lady? Where is her safety when she is taken and trying to be entered into juvie and she's being told the whole way that you'll learn your lesson? Where was her safety when she returned to school and was taunted by that same resource officer? Like basically he didn't hit her hard enough because she was back in school. That's what I'm asking. We also need to have a separate use of force policy for our juveniles. There is not a separate use of force policy for school resource officers. So that means the same force that they can use on a 30-year-old man, they can use on a 5-year-old. So that's what we're looking for, and we're looking for the 1.9 million that's spent annually to be reinvested
Thank you for your comment.
student care. Thank you.
Our next speaker, Racine Ector, followed by Vanessa Perez, followed by Yandel Love.
Palmdale, Lancaster area. I want to say that my child was one of the kids who were contacted by the deputies. A young white girl said that money was missing and my black son was the closest thing to her. I got a call after he was searched and told me, your son had police contact. Where did he get a Gucci wallet from? Nobody let me know anything. Fast forward a year later when my 9th grader starts, the school called me and said, your daughter has been being bullied and the bully attacked her today. And because she defended herself, we're suspending her. When I objected, the bully came back 5 days later, jumped on her again, expelled my daughter. Last month, I had a meeting with the school district, not only during the expulsion, but they counted the days that she was expelled as my child not being in school, threatened me with truancy because I wasn't having my child enrolled in the school when you expelled her for her first offense. It was no due process. It wasn't other means that took the time to say, does this child need counseling? What's going on? Does she need any type of help? When I took my daughter for her physical for that following year, the doctor pulled me out and said, your daughter told me she wanted to commit suicide from everything going on from this situation at school. Do you think they reached out and helped me? I had to remove my daughter from this school district. And I'm still fighting to today. It's been 1 month since I went to that school district as Raquel's my witnesses. That principal, that school district lady, Miss Rissling, and Aaron Foley sat there in this meeting and laughed when I told them my daughter thought about committing suicide. And I said, I want that expulsion removed off my daughter's record, who's an AP student, who's all A's, who's a leader. The first time ever been in an altercation, and you call me the day she's assaulted by the bully to let me know she's been bullied? Now ask for the parents to be involved. Can we talk with the parents to see what's going on? We don't bring that in here. And
Thank you. That concludes your
they
comment.
to discuss the things that was going on and my child not feeling safe, they retaliated against my daughter. Come get your daughter from school. Somebody said something, she needs to be sent home. And then they use that against you to send it home to make you look like your child is bad. No, y'all need to do your.
Thank you. That concludes your comment. Our next speaker, Racine Ector, followed by Vanessa Perez. Vanessa Perez.
This is the last public comment.
We have two speakers. Virtual public comment.
This is Vanessa, the mother of Joseph Perez, who was brutally beat by the Interim sheriffs on July 27, 2020. Joseph was punched over 100 times by professionally trained deputies. Deputy Paul Sedano was one of the deputies. He was actually the last deputy who wrote on his incident report. He deemed his punches took the desired effect. Deputy Paul Sedano gave the last punches 108 through 121, then deemed his punches took the desired effect. Remember, these are the words. They're straight from the incident report. This deputy, Paul Sedano, has been hired, or should I say rotated and transferred to work as a school resource officer at Nogales High School in West Covina. My daughter attends this high school, Nogales High School in West Covina. The day I found out that Deputy Paul Sedano, the deputy that used severe excessive force on my son, was working at the same high school where my daughter attends, I went directly to the office and they confirmed it for me. I demanded to speak to the principal or someone in charge with authority. I sat down with Mr. Felipe Partida, the vice principal of discipline, September 1st, 2022, who worked side by side with Deputy Paul Sedano. I shared my concerns for my daughter's well-being at this point, and she's been affected firsthand by the actions of Paul Sedano. To have to see the man daily and see him for 8 hours at our safe zone, because school is supposed to be all students' safe zone, right? I informed him he cannot provide a safe zone for my daughter under these circumstances. Vice Principal Felipe Partida has done nothing to protect my daughter. Instead, what his staff has done is when concerned parents call to verify that Paul Sedano could be in fact in danger to other students, his staff defamed my son and gave misleading information and said my son was a gang member.
Thank you.
Paul
Our next
Sedano's
speaker,
actions were justified.
Allende
Once again,
Love.
there was no concern for my daughter's well-being.
Thank you.
Yeah, we need to hear from everyone. I'm so sorry. Understand. Just trying to everyone be able to have their say. We're going to take this up anew. We're not going to end this discussion of school resource deputies. We just don't have enough time to give it, and I'm sorry, but I'll make sure the next time that you have all the time you need to tell us what you want to say. And I apologize. Anyone else?
Our next speaker, Allende Love.
I'll be as quick as I can. I just want to start off by making it very, very clear is that if these numbers were for white kids, there would be no school resource officer contract with our department right now. The problem is that we live in America where it's permissible for anything to happen as long as it's to Black people. But we have again yet failed our Black students at so many different levels by permitting this to happen. This is completely egregious, and everyone should be disgusted right now by the numbers that they've seen. If that doesn't move you to act, then you are in the wrong positions, and that is to everyone here, including myself. So what I'm saying is that from this point, if we hear this conversation and we say, hey, we know that school shootings are a major problem in America. We know that. We also know that the most important child to save in that situation is the potential shooter, and an officer can't do that. An officer is not the person to unload or unpack the traumas that that person may be experiencing. We need therapists for that. We need counselors for that. But we can't get those people if we use $1.9 million for a contract that only promotes the incarceration behind those students. We have to be able to understand, first and foremost, that we're not just showing our intentions with what we say. We show that where we put our money. Where we put our money shows exactly where our heart lies. So if we are not understanding that our investment that we use is not just an investment into our security, but also an investment into our students' futures, we have to understand that they need these programs. They need after-school programs. They need therapists. They need counselors so that we can produce the best tomorrow for everyone to be able to experience. But instead, we're investing into the school-to-prison pipeline that then will produce their incarceration later. So I don't want to see a bunch of people saying what they want. I want to see where their money will be moving, and I want to see you guys show this same energy in Lancaster. Please come up there and give the same presentation that you guys did.
We're due May 13th in Palmdale. Do we have any other speakers on this topic?
On this item, we have Helen Jones, but that's it. And we have 7 general public comment.
We're going to have to end this session. It's 1:15. I am so sorry. We have too many items on our agenda. This topic is too important to wedge into a few more minutes. So Danielle, can I ask that we agendize this for a further discussion of the issues that Dara raised, which are truly troubling. And as I said, we're going to have a town hall next on May 13th. It's a Saturday in the Antelope Valley, and perhaps we can add these issues to that agenda as well. Thank you very much.